Hey y'all, I'm Ada K, and I must confess, I'm a trial junkie. I enjoy viewing trials as if I was the seated juror. So grab a cup of java, get comfy, and join me as we hop into court. And don't forget to comment, like, and most importantly, subscribe. And if you're really enjoying the channel, please join our membership. Welcome. Good morning to you all. Those who are waiting the Sarah Boone motion hearing, day 2, and the jury selection, voir dire. We are going live right now for that. I am Ada K, and I have 2 lives going. I have this side of my screen, the Sarah Boone, this side of the screen, Melody Walker Ferris. It is a day of female murderers. I tell you what. Sarah Boone has been charged of unaliving her boyfriend / fiance in the suitcase. They played hide and seek after drinking a bottle or 2 of wine, and she forgot he was in there and he became unalive. On this side of the boat, we have Melody Walker Ferris, who decided to unalive her husband. Supposedly is charged with unaliving her husband and then putting him in the burn pile. I mean, my gosh, y'all. We got 2 fascinating women on our docket this morning. So grab yourself a coffee, get ready, and let's go to trial today. I want to thank Pretend Justice for becoming a new member. You are so freaking awesome. Yay. What a wonderful day for me to start my day. Appreciate you so very much. So on the Sarah Boone side of the boat, we have some new information. Let me share screen if I can. Share this. And I'm going to share it with everybody this morning until court starts. How about that? Everybody will get to see it until court starts. How about them apples? Might as well share with the class. Me going to share with the class. So we have, this appears to be in Miss Boone's handwriting, and it's just a little quick docket. It's an evidence control sheet. Case number 20CF2603, Boone, Sarah, Division 20, Judge Kurtnick, Clerk McCree. She crossed out whatever that is. Motion in limine, date 10/16/2024. It's just basically the state saying that she's stating that they have given the state A1 CD, DVD, B, 2 complete copies of Depot of Julie Harper PSYD, C, 3 complete copy, a Depot of Tina Werther MD, and D, 4 CDs, DVDs. Okay, that's interesting, none to say the least. And then we have yet another document. Yep, there was another filing. I mean, they're filing all the way up to the last minute, y'all. Good morning, Miss Eddie. Good morning. Good morning. Okay, let me add these to stage real quick. Get it to where I can read it. Also, we have the Sarah Boone of State of Florida versus Sarah Boone. Defendant's objection to state's digital exhibits. Now, I'm sure we're going to deal with this morning. The defense objects to all cell phone photo evidence the state intends to introduce at trial due to relevancy, foundation, unknown original date, and that it is repetitive in nature. The defense objects to all cell phone data, video evidence the state intends to introduce to trial due to the relevancy, foundation, unknown original or origin date, hearsay, and Crawford issues. The defense has no objection to the following digital images or evidence. Wherefore, Sarah Boone, James Owens, submitted digitally. So, okay. They are trying to keep out more evidence. How does that not surprise me? That doesn't surprise me none, to say the least. That's pretty damaging evidence. I will say that, y'all. I will say that. Okay. We've got everything up and running. We're just waiting. Good morning, Miss Jar. Good morning. Good morning. I have going at both at the same time. It looks like the Melody Walker Ferris case is getting ready to begin. We have two trials going on at the same time. So if you are over at Miss Boone's and want to watch the Melody Walker Ferris while you wait for Miss Boone, hop on over to that live. I will announce on that live as well when Miss Boone starts. She may not start for another hour. We do not know. I know the jury was told to be here at 10 o'clock, but I do know they have some motions and stuff, and they're supposed to start at 9 o'clock Eastern Coast time. We are Central time here, 8 o'clock in the morning. Thank you so much for being here. I appreciate it. Good morning, Miss Ronnie. Are we tired? Dang, yesterday was a long one. I didn't get to sleep until 2:30 in the morning, y'all. And I was up by 7. I am going to crash and burn. I might as well take my meds while I'm thinking about it. Hello, Toy. How we? Oh, I caught it. How we doing, love? How's everybody this morning? Missed you last night, Toy. I went live and showed the voir dire that I didn't know was playing yesterday. And you missed Zach. You missed Zach. Our infamous Zach was there. You missed him, love. I got to get my stuff done. I forgot all about it. So thank you for joining me this morning. I appreciate it. Speak of the cutie patootie. Zach is lurking while he's working. Appreciate you, Zach, so very much. Thank you so much for joining. Toy, if you want to, get even with Zach, hop on over to the Melody trial. He's here too. I am so sorry about that, Toy. I feel you. Been there, done that. Been there, done that, love. Blessings to you and that little beautiful pup. Zach, hola. Okay, we have motion in the Melody Walker trial. Judge is getting ready to come and sit down. Now, this judge is it's just as comfortable. He's just as pleasant and kind. He's kind, he's smart, he's thoughtful. And that's a reference to The Help, where the maid tells the little girl, remember, use kind, use smart, use is important. That little girl was so cute in that movie. Wonder where she is today. I wonder where she is today. And I left all my clips in the other room and my hair is dragging. Howdy, Jack. My gosh, you can tell who's from Texas, right, Ronnie? So, real quick, just a quick catch up. We had a conversation back and forth about Melody and whether or not she would have received her husband's benefits, insurance benefits. Well, I told y'all that I did not think he would, She would, because the situation is that he was murdered and that the insurance company would not pay out. I contacted a lawyer, and this is what the lawyer said. No, she would not get the payout because Georgia, like most states, has what is called a Slayer statute that essentially says if you partake in the murder, you don't get to benefit from the death via life insurance, estate, and sometimes trust. This has most recently been in the Coy Richens because Eric left behind a decent sized estate. She would need to have a death certificate at the very least to collect the life insurance policy. But if there was a pending criminal trial against her for murdering the person, the policy was on the insurance company would not pay until it's resolved. So if she is found guilty, then the beneficiaries would be the sons. Should they be charged or and found guilty, they would not receive the money. And if a third in line was not listed, there'd be no payout. So at this time, she has nada money from that life insurance policy. Welcome, everybody, our newest member to the tribe, and that is Pretend Judge. She's awesome. We met her last night. We enjoyed her company. It was awesome. So thank you so much for joining. I love it when we get new members and new people. By the way, please do the YouTube thing. Comment, of course, like, subscribe, and if you feel feel that you love us that much, join our membership. We do have fun. By the way, just so you know, I'm doing something special. I'm trying to reach 3,100 subscriptions by October 31st. And if you subscribe, put I sub in the comments. And then if you become a member at any level, you will be entered into the drawing with 10 entries for a Starbucks. And it's way over there. One of the really nice Starbucks tumblers. Those are nice, y'all. So don't forget to do the YouTube thing. Greatly appreciated. Thank you so very much. Good morning. Hey, Ronnie. Hello, Eddie. Hello, Tori Jar. So, what did y'all think about yesterday? Those who joined us last night, we did a late night impromptu live where we watched the voir dire of the jury, potential jury members in the Sarah Boone case. What did y'all think about that? I thought we had a little too much fun. I was so involved. I looked down at the clock and it was like 12:47. By the time I got out of the office, it was 1:10. Before I fell asleep, the last time I looked at the clock, it was like 2:27. So it is going to be a very long day for me, but I'm excited for it. What? I heard some. Oh, guys, let's look. The mic is hot. Uh-oh, let's read this real quick. Brig Brother, yes. Yeah, I'm reading it. Please come out. Who are you wanting to come out? Why? Good morning, Adair. How's for you know? How for I'm reading some text in the Melody Walker Ferris trial's getting ready to start and they have a hot mic and I'm reading it. If you're it's slow read. Good morning, Adair. I dare you. No, I'm kidding. Please come out to the corner after. This is weird. Just last night back into the course of ruling. Work within that and then Rusty interview, which is a part of number 1. Oh, They don't know 2 minutes to evidence just yesterday. You're great at that. It's 2 hours and 32 minutes. I like it. Oh, that's the state talking about their evidence. Someone needs to tell the state that their mic is hot. And then there's some timestamps. Oh, I love it. And there's a pause in 30 minutes. So obviously we're going to get some video. And 30 days, Mr. Barton is attorney. Discard set on top. They start until 38. They're planning their day. 48 years. Attorney steps. They are planning their days. And then 1 minute, 1 hour later. Oh my gosh. Wow. Y'all, we're eavesdropping legally. We're legally eavesdropping, y'all. That is interesting, man. They're talking about the deposition. Attorney makes him say about ready to talk, and he wants to talk, and Rusty's sitting there listening. Oh my God, this is a scoop inside the. Oh, y'all gotta go over if you want to hear more. Hours so on the page. Oh, y'all. I like it when we get the skinny. Then I don't want to play it like that. Oh my gosh. I'm not trying to hide under room 106. Want to play anything around. If they could do that, they're welcome to. Oh, are y'all watching this with me, y'all? I don't. Somebody needs to get a hold of him. We're listening. We can't hear it because the mic is off, but the captioning is getting it. Oh, I love it. Cocobella 23. Okay, I have 2 live streams going. If you want to hop over to the Melody Walker Ferris live, the court hasn't started. It's muted, but the state is prepping for their rest of their questioning of the ex-boyfriend of Melody that she was dating at the time of the ending the life of her husband, and the captioning is getting everything they're saying. And so we're reading it. We can't hear it, but we're reading it. Oh my gosh. So it's 2 hours and 32 minutes for the deposition. Talking about all kinds of things there for about 40 minutes of them sitting with the attorney meeting in a spot. What? Wow. I can't read it fast enough. I know in this, I feel it's almost like we're hearing things that we shouldn't be hearing. Oh, tell him what his attorney said to impeach him. Nonsense finds women's. Oh, I can't. It's popping too fast for me to read. The witness was scared. This could be adaptable commission-based attorney if the initials is. Oh, they're going to try and impeach him. Oh my gosh. They'll probably get pretty close to objecting, you think? It's a while since I've listened to this recording. Y'all, is there a lawyer in the office call for? Oh my gosh, y'all. Adair, look at the video next to my head. The words are popping up. There's no sound, but there's captioning. The state mic is hot. So the captioning is picking up everything he says, even though we can't hear it. And they're planning their strategy. We're going to do this. We're going to do that. We're going to impeach here. We're going to try and do this. And y'all don't see the words up on my screen? It's right here. Go over to the Melody Ferris trial, not the Sarah Boone. Let me see if I can put this on both of them. There we go. It's on both. So no matter which one you're watching, you've got it here. It's about 2 minutes, and we're just going to tend officially. So this is what I'm talking about on both sides of both lives are watching the same thing. And if you look on the screen, law and crime, right there it says, well, I got to change my format on this one. I got to do that. Okay. You will see. Well, no words at the moment. Boy. Oh my gosh, y'all. Oh my gosh. That was interesting. Did they stop the hot mic? No. Oh. Okay. You see, that's what I'm talking about. Talk Extreme 20. I'm just going to skip through that. See, they're planning, they're questioning. But wow. I don't know about y'all, but I find this so intriguing. I love to be able to see what they're thinking and saying. So they are going to try and impeach him definitely on one thing. Him meaning the boyfriend that was on the stand. He's ready to talk. Oh my gosh, about the conversation, but I assumed this before leaving to that conversation. Oh my gosh, y'all. This is so cool. Do harm is what it was. So this is interesting. I'm just enjoying watching the show of the captioning. I'm a little mesmerized. Good morning, Missy Morales. Good morning. What y'all are watching on the Sarah Boone trial is the open mic captioning, and we're eavesdropping in to the states getting prepared to continue the questioning of the last ex-boyfriend, the boyfriend at the time of the unaliving in the Melody Walker Ferris trial, where she unalived her husband and put him in a burn pit. And so what's happening is that the lawyers on the state, or the prosecution on the state side, is prepping for their questioning of this gentleman, and their mic is getting captioned. OMG, y'all. I love it. People forget about the microphones that are in front of them all the dang time. All the time. And yeah. So how's everybody doing this morning? For those of you who didn't know, I didn't know that yesterday that the voir dire was aired in the Sarah Boone case yesterday. Yepers, yesterday. So this morning, they are going to be back live, and we will be there as soon as they pop up something with Sarah Boone. We'll be there. She, yesterday, it was interesting the way she was behaving. And do you know what I discovered, guys? I discovered, y'all ready for this? I discovered that she, for some period of time, worked as a paralegal. She was a property manager and a real estate agent. Oh my gosh, y'all. So, yeah, I am a loss for words on that, but it does make sense now why she thought she can control and do what she's doing because she thinks she's been a paralegal, that she has the knowledge of a lawyer. Yesterday, she was writing so fast, sending things out. She was just all over her attorneys. And at one point, her attorney went, like, stop and pay attention. Good morning to Law Trial TV Live. We are so blessed to have you. If you want to watch trial without commentation and without any kind of wordage from people like me, go to Trial TV Live. They are fabulous. I do get my feeds from them, and I want y'all go love and support them. We'd appreciate it. Please go and subscribe. Good morning, everybody. They're saying good morning to me. Good blessed morning. If I could spell this morning, y'all, I'm struggling. I'm really struggling to type. So they were also so kind to turn on the closed captioning for me, which was awesome. Now, we know the jury has not been seated in the Sarah Boone. We are still waiting for the Melody Walker Fair's trial. It appears that the conversation has ended. We are going back to the exact live. It's fun. Oh, by the way, yesterday I actually had 4 lives, 3 live at one time in the 4th gear. My computer finally went, I think you're doing too much, my love. I needed Braxton. Braxton, I don't know if you're watching or listening, but just know that we miss you. You are a very valuable person on our team, and we hope you're enjoying your new job, and we hope to see you again soon. We miss you, friend. We really do. Let's see. Ronnie and Zach. Zach is our newest mod. Everybody, welcome Zach as our newest mod. Yeah, YouTube wasn't liking him the other day, or most days. Sometimes his comments were getting through. I wonder why, Zach. Let's see. Sarah Boone is, if you notice, and I kind of was talking a lot about it yesterday, but I thought it was kind of funny. I'd not seen this in court, but I know it happens in the jail. If you were in a jail, a prison, a mental hospital, anything like that, you can't have a regular pen. I don't know if I have a regular pen like she had. No, I don't. I'm a pen junkie, and I like Tool is my favorite, but you can't have this. The only thing you are permitted to have inside jail, are y'all ready? I kid you not, is this. And not even this because it's too thick and it's too big. It's that real thin cheapy pen. You cannot have the pen itself, only the ink refill. And so she was writing with that, and it's much smaller and more difficult to hold on to. But boy, she's mastered the art of it because she was going at it. Oh, you're blushing. Oh, Zach, I didn't know that you were capable of blushing, my dear. And for those of you who don't know, Zach is somewhat of a comedian. He's a fisherman. He loves his fish. So much so he kisses them. Yep. So much so he kisses them. There's the picture to prove it. Oh, we gotta wiggle. Come on, guys. We're ready. I wanna start some really loud and obnoxious music, but it's too early in the morning. I can't believe I'm here. On time and awake. Although the yawnies are gonna come because I didn't get much sleep. Ronnie, did you get any sleep, my love? I feel bad. You were up with me at midnight, 1 o'clock in the morning. We got off of our live at 1 o'clock in the morning. Can you imagine? Oh my gosh, but it was interesting. It was fun. So I look forward to it. Oh, I forgot I got to do comments. Let me see what they said. Good morning. Good morning, Trial TV Live. Thank you so much. You are awesome. Oh, by the way, over on this boat over here with the Sarah Boone trial, she wore the same suit for 2 days in a row. However, I got an itch. I'm sorry, guys. However, she had a different shirt on. And she started looking pretty disheveled by the end of the day. Yes, I do some sleep. I don't have to wake. Yay, I'm glad you didn't have to wake up at 5 a.m. They have some technical difficulties. Thank you, therapist Juno, over on the Sarah Boone side. So let me get this one. I don't know. I got to figure this out. Nope, wrong one. So the bottom one over here is going to be Sarah Boone, and this one, nope, wrong one. It doesn't work like it should. I got to figure out which one. There we go. Trial TV bot. Thank you, following Trial TV. Yes. Ronnie, can you pop up the Trial TV Live Discord or their YouTube stream? We really want y'all to support them. I appreciate you watching it with me. Please stay with us, but go and subscribe over there and just click the like button. Support them. Leave your DNA over there because without people like them, we would not have the court feed. They are partnered with RA and his media channel. I forgot. I'm reading. By the way, I am in the process of setting up my own media, and I've already got the domain name. Oh, morning, therapist. Good morning, little miss. All right, awesome. We are going. Thank you so much, Ronnie. We are. I have ADA Media. Now, ADA is my name, but it also can mean Americans with Disability Act media. So it's media that focuses on servicing the disabled. So once the trial for Sarah Boone goes live, even though we have the Melody Walker Ferris trial going, I will be interpreting the Sarah Boone trial. And when my partner in crime interpreter is free, she will hop on over. She does have other jobs, but she will hop over. So, yay. I'm learning how to balance two things at once. I am so grateful for y'all. Thank you for being here. Like I said, the yachties are coming. Forgive me, y'all. It's going to be a yawny day. And it's an allergy-ridden day. We have allergies here in Central Texas. always have allergies here in Central Texas. When do we not? Did y'all know? I didn't know that when I moved up from San Antonio to where I live, that the area where I live in Central Texas is the place in the world that they test all allergy medications. Ooh, we have Sarah Boone. Okay, Sarah Boone is getting ready to hop. Let me get this up and going. I don't want to hide Trial TV Lives. Tracy Love, give me a minute and I'll talk to you. We're going to do this because I want to. I've got to my sister, my beloved sister. So just give us a minute. Trial is going to start. I'll be right back with you in just a second. Sorry about that, guys. Y'all know, if you don't know, my sister is living with terminal cancer. She's in an okay place at the moment, but when she calls, I drop everything. She is my number one priority. So please understand and forgive me. She comes before all work, and I don't want to cry. So I love her, and she's okay. She's okay this morning, but there were just some things that we needed to discuss real quickly. So thank you so much. Well, same suit again. They need to get away from the yellows and that lime green with her, because with the chairs and with her skin tones and with the suit, it looks like crap. Looks like crap. Sorry, guys. Not sorry. Those of you who are on the Melody Walker side, we are still waiting. There is movement. So we're going to be talking about, because I don't want to put you guys just on music on the Melody Walker Ferris trial. So you're going to hear me talking about the Sarah Boone. And once both trials are going, then I'll mute back and forth. But I greatly appreciate all of y'all. Miss Sarah Boone, they are back into the original courthouse number 12A. Once the motions and hearings is all done, then they will move over into the big courtroom for the jury voir dires. They've got 45 people in there right now. Why do we not have sound? Thank you for the captioning, Trial TV, but we have no sound. Sarah Boone is being sworn in. She should have stood up for that.
Ma'am, good morning. Do you state your full name and date of birth for the record for me?
Why do we not have sound? Let me re-engage it to make sure it's not us. It is not us. Why do we not have sound?
Prior findings.
There we go.
We're here to conclude the objections as identified in the state's response.
Once again, we found out yesterday Miss Sarah Boone used to be a paralegal for a short time.
Reviewed the objections and the defendant's fifth amended reciprocal discovery exhibit list. Anything else we need to address, state, before we begin addressing those objections?
Judge, I do not see a written order from yesterday's rulings on the court's website. I want to make sure I am crystal clear as to what the court has said is going to occur during the trial regarding opening statements by either party and so on and so forth, so that I am not in violation of any motions in limine or any.
Good morning, Miss Kevin. Oh my God.
Presides over.
That's okay. Just keep listening.
Madam Clerk.
Good morning, everybody. Thank you for joining.
Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put at least on court minutes by the clerk's office.
I can't do anything about the sound or the feed.
Okay, that's what I wanted clarification on. Thank you.
On yesterday.
I just do want crystal clear clarification as to what we are both doing. Based on that, I have some things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment.
I like that they say madam. I love that. Madam. I wish you guys could see my setup.
You did not.
I got StreamYard, trial, and 2 more StreamYards going. It's crazy.
Madam Clerk is advised that court minutes were not prepared for the ruling from yesterday.
Oh.
Due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that.
Thank you.
Madam Court Reporter, how long do you think that would take you? Is that acceptable? Can we address it at 1:30 before we come?
Makes it very difficult to prepare for opening statements. When I don't know.
You guys.
No, I agree with you, and I'm not
She
trying
needs
to,
to sleep
submarine
too.
anybody or put anybody in an inappropriate box,
I
but
understand, but I need to know what I'm going to be allowed to say.
I don't disagree. But is 1:30 acceptable? Okay, well then, short of taking a break right now and having her create it, I don't know what else to tell you.
Y'all.
State?
We have an out-of-state witness and people that are scheduled to come in. So we do see problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning. So, Mr. Henderson, how much time do you think you're going to need, sir? Okay.
Guys, real quick, if you see me talking but don't hear me,
Correct.
because I'm doing 2 lives, I'm
Correct.
commenting on the other stream, not the one you're watching.
Okay. Mr. J?
I just need that ruling so that with enough time to prepare.
I want
I understand.
one on.
So the way I see it is we've got a couple of options. We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do. Or we can stop now. Madam Court Reporter can provide a rough draft of what was ordered yesterday. And we could go over it and review it, make sure that we're all on the same page as to what the court's ruling orally was yesterday as to the various motions and limits.
We're starting out good today.
Then we can continue with jury selection, or then we can pick up with the objections. I'm amenable to however it is you want to proceed. I understand your concerns of running afoul with a motion in limine. I totally understand that. But it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but prior to getting into jury
Hopefully.
selection so that I have time to rework what my opening statement will be based on the ruling during Mr. Henderson's voir dire.
Miss Kevin, that's right. Why don't you just go
then
watch the Ada
Ask
K
this question.
channel?
Assuming we get a
Which I'm
jury
gonna
this
start. I'm gonna
afternoon,
rename it
what are the
a little
concerns
bit.
with starting tomorrow morning with openings?
Ada
Is
K
it due
Media.
to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening statements and use every
Oh, I know.
moment we have to not waste these jurors' times until 5 o'clock today.
I can handle his more than I can handle Sarah Boone. Why they get that yellow, green, and yellow on that? Whoever's dressing her needs to get her away from
that
anything
acceptable?
with
As
yellow.
opposed to in
Look at
print?
that. Ooh,
She could go back and pull back the
She
audio
looks sick.
from
she
and
is.
re-review it and just provide it to us now? Okay. All right. Then we'll take a short recess. Just let us know when you're prepared to give us that ruling, and then we'll go from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor, thank you.
State or Mr. Owens?
Hey, Celeste.
What do you think? 10, 15, 20?
Hey, Celestial Force.
Okay,
how
great.
are
All
you?
right, we'll
Good
be in
morning.
recess till 9:45. Thank you. Yes, sir. Yes, sir. Yes.
Oh, there he is. Yay. Not on her skin
You're
tone.
talking
It is
about
not
the motion
flattering.
limiting regarding anticipation of
So not flattering on that skin
affirmatively
tone.
pled intent to use battered spouse syndrome evidence. Fine. Okay, well, that saves me some time then, so I appreciate that. All right, so do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present
Brute.
evidence in the state's case in chief in anticipation
You're
of
right,
the use
case
of
one.
the battered spouse syndrome defense at trial? All right.
She could
motion's
wear
granted.
more of an.
All right, we'll be in a brief recess till
She couldn't.
9:45. We're off the record. Thank you.
Okay, we're back over here. The Sarah Boone is in recess. I am also over with the Melody Walker Ferris that just started this morning. The ex-boyfriend is back on the stand. Yes, case one. She only has the one suit. She looks like she'll be wearing it every flipping day. I wonder if that's a lawyer number 3 are you talking about the guy sitting next to her in the blue suit? Each lawyer has a job they're doing on the team, whether one is controlling her, the other may be keeping all the documents and everything in order. I don't know, but I know that they have at least 3, if not 4 attorneys on her team. Yeah, I don't know that guy's name either.
In our motion, though, but paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916 Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452 Southern 2nd, 98, page 100, a Florida First DCA case from 1984, also quoting Williams versus State, 252 Southern 2nd, 243, 246 is the page, Florida Fourth DCA, 1971, Reed, R-E-I-D versus State, 213 Southern 3rd, 1110 at page 1111.
Trial TV Live.
Florida
If
5th
you hear
DCA
me doing this
2017.
caption,
Rudin versus State, 182 Southern 3rd, 724 at page 726, Florida 1st DCA 2015. So what we were asking for is in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled the battered spouse syndrome evidence, but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of the decedent.
Thank you. Response.
I just have one question as to what time. Are we talking about for Dyer? Are we talking about opening statement? At what time are we talking about?
During the testimony in the trial.
That was my takeaway.
Okay, he's absolutely correct.
Okay, then the motion's granted. So the court's going to rely on that specific excerpt in Holland, 916 7 2nd 750 at pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on a particular occasion, section 90.4041 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was, or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be granted.
Judge, just understand, put it on the record. It's just procedurally correct. Procedurally, before we can put evidence of that, there has to be a claim of self-defense. That has to come from someone. And in this case, we all know that has to come from this person.
Received and understood. Any other clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
No, Your Honor. And then the only other thing that we beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday at some point for the record for the 6 DCA.
Okay.
Yes, ma'am.
All right. Thank you. Anything further from the state before we proceed with the objections? Defense.
Judge, yes. Just my overall understanding is that the motions and the orders that the court has apply to trial and the organization or the flow of the evidence at trial. Certain things have to be presented before certain witnesses can testify. It has nothing to do with or dire.
No, he didn't look happy.
That
Forgive
is
me,
correct.
guys.
And
I
the
had
court
an
ruled
important phone
specifically
call.
on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. All right. Thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter today. Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that fifth amended reciprocal discovery exhibit list filed by the defense, I believe back on October the 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to, provide as to the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
One by one, I assume?
I think that's the easiest way to go. I know we start with item 1 and then go to 3, 4, et cetera. So we can ping pong it back and forth from there.
All right, regarding item number 1 on the fifth amended reciprocal discovery exhibit list from the defendant, I do not believe we have received those records.
Response from the defense.
We're referring to 1. 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
The defense has not received those records.
Okay. Motions or the objection is sustained. Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not Bates numbered. I do that myself. But what I have and what I believe is states 2 was 81 pages of records regarding treatment by.
I'm not talking about 2. You don't object to 2. Talk about 3.
Well, I do need to talk about 2 now because
Okay.
This morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense, which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Ms. Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be. And we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
At this point in time, the court is going to proceed with a Richardson hearing. Defense?
Judge, referring to our paragraph 2,
Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27th, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time.
the 81 pages that
The 81 pages are not at issue.
I understand that they were given Sarah Boone from the Advent Health report. The 119 pages, my understanding is we thought we sent them previously. We realized yesterday or last night that we had not sent them. So we provided those to the state as soon as we were aware that we had not given them.
And what do the 119 pages
strokes, and then whatever.
I had to switch feeds because I have 2 trials going at the same time. I really needed the captioning to keep up. I apologize. Look, it's the way it is. There we go. I got the sound.
issue? We're conducting a Richardson hearing at this time. So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things? Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the 3 prongs that I need to address.
Case 1, what did I just miss?
understanding is the first 81 pages were medical records of Sarah Boone that we had gotten from one of the previous lawyers that we had sent to the state. The other medical records were those that we had requested directly from the hospital that we got last week or late last week. And we just failed to immediately provide those.
When did you receive them last week?
I'm not sure, Judge. I have to get my secretary. We have to take a break and let me find out from my secretary.
Okay, I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what.
My staff is
Understood.
texting her.
All right. I'll make a note to circle back to this issue. Moving to number 3. Is this the Advent Health Winter Park Jorge not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
You want the exact pages that those,
Yes,
the BAC and the narrative are on?
that's what's going to be offered into evidence at this point in time.
Judge, we'll work on that.
Appreciate it.
I've got staff here in the courtroom.
So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize. You're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them?
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense?
Judge, we have not yet received those records. We had Sarah Boone sign a medical release. And we have
Get on the mic, dude.
various medical facilities asking for records. And we're just waiting on a response.
The objection sustained.
Case 1, he has a mic, he's just not using it.
Moving to 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours,
Elaine,
I
your
received
mic.
182 pages of jail records regarding Ms. Boone. Once again, I had to spend my personal time reviewing these records. Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through for the course of 4 years. The state just is having great difficulty understanding what, if any, pages of these records are relevant. On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225 goes through alcohol abuse, yes, type, spirits, not wine. Last used 2/23/20, several times a week. The intake screening also includes a history of violence towards others, yes. So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed, there's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that that was pre-existing before the jail. So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant, and it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just a lot of COVID screenings and blood test results, and we struggle to see the relevance, Judge.
Thank you. Response?
Judge, it's similar to the state about 10 days ago, sending me over 500 pages.
We addressed that yesterday. That's not germane to the issue.
As soon as I got the medical records, I sent them to the state. He mentions anxiety was pre-existing. Now, that's not what their expert, Dr. Werner, opined in her deposition, that the anxiety she may be suffering from at the jail was from being in the jail. So there are questions about that, but generally you get these records, as you know, when you have a forensic psychologist that's trying to evaluate a patient.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382
Good point,
pages
Your
of
Honor.
records are relevant? What specifically is relevant? What page? What date? What document? You're not answering my question, counselor. They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
I don't intend on introducing these exhibits. Potentially the doctors, the experts, Dr. Werner, Dr. Harper, to rely on these records.
The depositions of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper? If she has not reviewed these records yet, when do I get to depose her? Who's going to pay for the expedited costs for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records post deposition, post evaluation. The last date that I believe she saw Ms. Boone was September 30th or October this is also a problem, even if it's just going to be relied upon and not introduced. And I appreciate them letting us know that they don't seek to introduce these records into evidence, because of course, experts can rely on inadmissible evidence if within the course of that area of expertise, it's the type of evidence that's routinely relied upon. But how are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. We would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens?
Judge, I don't want to go any trouble. I'll wait. I will not have Dr. Harper review.
So she has not yet reviewed these yet, correct? Okay.
I don't want to get in a situation where we will take another deposition. So I'll wait. I will not ask her to review.
Okay. State with,
That was the only purpose.
okay. So state, understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts, does that cure any concerns that you have?
Yes, sir.
All right. Then based on counsel's representation, the court's
Good
not
morning,
going to
ADHD
sustain or
Jelly
overrule
Bean.
the objection, as the defense has identified they are not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11. There's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
Judge, the arrest reports are not listed as evidence in itself, but the reports may be used to refresh the officer's memory if needed during their testimony.
Okay. Does that cure that understanding?
Yes, sir.
Okay. All right. So based on Mr. Owens's representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence. Moving to Exhibit 17. No, I'm sorry. 16.
Miss Boone's got some
16 is a
makeup on,
repeat of
y'all.
11.
She's got
So the
eyeliner.
court's going to adopt its
Wonder if it's burnt
similar
paper.
with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing?
Yes, sir.
Okay, so court's same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection?
No, Your Honor.
Response?
The defendant is not intending to introduce the jail call.
Okay, the objection is sustained. 18, prior criminal history of Jorge Torres not yet received by the defense. Has the state received that?
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously we have to provide, if they can't get it through due diligence, rap sheets of witnesses, but he's not a witness. So we have not done anything other than had discussions about prior interactions with the state attorney's office.
Okay. Response, Mr. Owens.
Judge, we're referring to the prior record involving Sarah, that Sarah's aware of.
Okay.
I know we had some priors in Pennsylvania, and Massachusetts. We're not referring to them as well. We're referring to the ones involving incidents involving Sarah.
I'm just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent? Can't rebut it.
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion. Because if it's oral testimony, that may be a different critter once the overt act is established under Holland.
Judge, she's gonna testify to it, and then, it kind of ties into that evidence being used to refresh the officer's testimony. The officer's testimony, we believe, is gonna corroborate Sarah Boone's testimony about her injuries, photographs, officer visibly observing injuries on her. That's the nature of this. So I don't think there is going to be anything about a prior criminal history other than what she's testifying to.
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that, that we have to cooperate and ask the court to take some judicial notice that there was a case file that was set up that handled that criminal prosecution.
Okay. Mr. J?
I don't know that papers generated by a government agency is relevant. The disposition of the papers that were generated by some government agency is relevant. What's relevant is if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits. And that's what our objection would be to believing that what was represented was a criminal rap sheet.
Judge, part of battered spouse syndrome, Dr. Brennan will testify, I assume Dr. Crump will testify about it, Dr. Warren will testify, is this feeling by a victim of being battered, that she has nowhere to turn. His family can't help her, she has no room. The state attorney dropped 3 of the charges. 3 separate times Jorge Torres was arrested, charged with violence against Sarah Boone. At her request, she wanted them dropped. That's part of the syndrome. But in addition, in her mind, she felt like the state attorney had.
Are y'all able to hear him speaking, Owens, at all? Because I'm captioning is having a hard time catching him. Yes. Elaine, your mic. Hello, Elaine. I have it ganged up 100%. Sorry.
As to whether or not she felt helpless because the state attorney's office was not prosecuting Jorge Torres when she was.
But that all sounds like oral testimony. And again, this goes back to this is an exhibit list. What are the exhibits? Tangible, physical.
We may want to introduce something in a court record indicating that the state attorney dismissed.
Okay. What does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of Jorge Torres Jr. not yet received by the defense. That's the line item in your exhibit list.
I'll withdraw the prior criminal history.
Okay. All right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19, Orange County Sheriff's Office investigative workup report. Response.
That's to be used to refresh the officer's memory if need be during their testimony.
Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but if it's it's not sought to be introduced into evidence, then I will accept that representation.
Okay, so accepted. Your objections overruled
Comfort
based
break.
on
I'll be
counsel's
right back.
representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding Jorge Torres. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I had the wrong, I color coded this and I miscolor coded this one. Okay, then based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further, because this we kind of addressed this as well with number 19. Anything further, argument state. Anything further, argument. Okay, I'm going to overrule the objection as to as this point in time, because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence. Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01660-0. I understand the state's objection as to relevance and hearsay. Response?
Judge, Brian Boone, we anticipate is going to testify for the state, and he testified for the defense, and he may be considered an adverse witness or hostile witness, and so we may attempt to establish either bias on his part based on some of the documents or orders in the court record, or we may reflect for impeachment purposes the fact that he has not complied with some of the orders, and that the reason being is because of his feelings for the defendant. You know, he's now got full custody of their son and has had full custody for 4.5 years. That was not the agreement they originally had, and he was ordered to pay alimony, which he has failed to do as a result of her being incarcerated. So there's litigation going on. Brian Boone has counsel, Sarah Boone does not, and that force
What does
he says.
what does the non-payment of alimony have to do with what's happening in a family case?
Well, that, Judge, that goes to his testimony, that goes to his credibility, whether or not he can be impeached, that her in the position that she's in now, he's biased. And to show that he's biased, that he has not paid alimony for, he's supposed to pay $1,000 a month for a number of years, and he's just failed to comply with the court's order. That shows his personal bias or feelings towards it.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge in the Ninth Circuit Family Division. And I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress about those issues. And it sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of a hearing coming up. She's not represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a violation of an order to pay alimony, what is?
Well, there's a final order about his obligation to pay alimony. And I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into under cross-examination.
But it sounds like there's pending litigation, including a relocation and I don't know because that's not my case. I haven't looked at it.
That's been decided. He has been able to relocate. I don't know all the ramifications. I'll look at the clerk file. I think we had subpoenaed the custodian of the records of the clerk file. I'll look at it and I'll let the court know and the state know.
Can you all approach just for a moment?
This is getting good, y'all. He's like, I gotta. Sorry. Yes, I know. I muted case one. I have 2 lives going. I'm going to do this to both. I have 2 lives going right now on this side of my screen. I have the Sarah Boone, and then on this side, I have the Melody Walker Ferris trial going. So if you see me talking and you don't hear me, I'm talking on the other live, respectfully. But we are going to be in a little recess on the Melody Walker side. So let me get that up and going. I shall return. Okay, back over here to the Sarah Boone side. Wait a minute, maybe not. What? He said? What? It was a lie, Ronnie? He said that Chris and Scott did it? Oh, I got to go back and rewatch that on a separate feed. And he said it was a lie that she said, I got to bring this forward. The boyfriend said about the body being in the burn pit before the body was found was a lie. Why is he lying? Holy crap. Y'all, love you, Sarah Boone. You're just starting, but this trial's getting heated. Okay, in the Sarah Boone case, if alimony is ordered, it still is ordered and will continue until she's convicted. Depending on the state, depending on the jurisdiction, it may be put in a holding status and he still pays it and they put it in trust, or she still gets it. Oh, really? He was lying to save his heirs? Oh, crap. I'm going to have to rewatch that. Sorry, y'all. I'll do that in the morning. Good morning, Karen. Good morning. Wow. Y'all, I have to hop over here. Okay, I'll be right back over on the Boone. I'll be back in a second. Oh, don't they look all chummy and sweet? Look at the behavior. Oh, they're best buds. Zach, you're losing out. She's got a girlfriend.
All right, thank you all both for your arguments and clarifications. Based on, the court's going to overrule the objection at this time for the reasons discussed at sidebar. Moving now to 23, the policies and procedures of the Orange County Sheriff's Office regarding Miranda. Have those been received by you, Mr. Owens?
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay. All right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action. Moving to 25, records from Tealwood Park Apartments.
Judge, we never received what we wanted. We're not seeking to introduce that.
Okay. Based on counsel's representation of not seeking to utilize it, court takes no action on that objection. Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay. All right. Thank you. Moving to 27, the video footage of the arrest on February 25, 2020.
The defense has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
State, do you have such an item in your possession? News footage?
No? Not that I know of.
All right, but we have not received it, so we don't have the evidence.
Okay. All right. Based on it not being received, court's going to sustain the objection. Moving to 29, the iPhone photo file name. Not going to read it. It's very long.
Judge, I do not intend to introduce 29.
Okay. Court takes no action based on counsel's representation. Moving to 32, iPhone photo. Yeah, I'm sorry, sir.
29, what is the ruling?
There is none, as the defense has advised they are not seeking to enter it into evidence. 32, another iPhone photo file name. It's very long, so I'm not going to read it.
Defense does not intend to introduce.
As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to 48, another iPhone photo file name, 505 period JPG underscore embedded underscore 1 underscore 772.
We would stipulate.
All right, the objection is sustained based on stipulation. Moving to 59 and 60. I understand your objection. State any response.
Any and all exhibits previously listed by the state?
Mhm. Yes, sir.
Judge, Mr. J is a smart lawyer with a lot of experience. He's board certified. He's filed this motion in limine to disallow the battered spouse syndrome twice. And yesterday, we were forced to disclose the overt act that constituted our defense that tied in with the self-defense. And so tactically, he was able to get us to that posture, so he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone. And state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that. But that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission, that constituted second-degree murder. So because of that, we have to list everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So in an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day. And that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes to directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
Any response, Mr. J?
Yes, sir. Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion in limine. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion and that if that is the proffered testimony, that that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. They weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do. And we're making every effort to make sure that we understand how this trial is going to go down and how and Ms. Boone understands how the trial is going to go down, because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day. And right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony. Unless there is, then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that starts at 11:12:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah. Shh. That's our case. That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not, she let him remain for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical examiner comes in and says, Jorge Torres, George Torres, died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Any rebuttal?
I wanted that in writing weeks ago. She was assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, state's expert. The characterization that Mr. J just gave about her testimony, I do not agree with. There was 4 of us there. Dr. Warner, 5 of us there. Dr. Warner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment. Because I can't testify to what she said. The 2 prosecutors can't testify to what she said. The only two people that can testify to what she said is Dr. Werner and Sarah Boone. We dispute their characterization of what she said. That's just going to have to be testified to by Sarah Boone and then Dr. Werner. And jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder. It was something I was asking for a couple of weeks ago. Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraphs 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the costs of expedited transcripts. And I just want to make sure they meant to overrule that request.
I apologize because I was just looking at what was articulated in the exhibit list, which was any and all relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. So if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed later.
I believe those are the same witnesses that they've listed in regards to the prior incidents, the deputies that went out on the call outs and the cases that resulted in cases to the state attorney's office and 911 dispatchers.
Okay. Is that accurate, Mr. Owens? That October 3 states list?
I don't know.
But yeah, we don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Okay.
Judge, again, I'm not complaining. Been on the case 45 days as we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose it. Based on what Sarah Boone has asked us, I want this witness, I want this witness. We've made attempts to comply with her request. Whether or not we're going to call them, the law says, the case law says, you know, Sarah Boone has a right to trial. Sarah Boone has a right to testify. Sarah Boone has a right to appeal. I believe those are the three fundamentals. But the defense lawyer makes the decision about which witnesses to call. So although she may want some witnesses, she's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them. And it may not, we may not call many of those that she wants to, but I believe my right to do that and to present our defense with our witnesses is paramount. And she does not have the right.
Okay, thank you. All right, court's going to take a brief recess to address this and the Richardson violations. We'll be in a short recess. Thank you.
Okay, guys, this is getting fun. So, what are y'all's humble opinion? Wendy Mueller, welcome, beloved. Oh, Karen, welcome. Case one, good to, well, I've already said good morning, but good to see you. Oh, Zach. Oh, Zach, really? I'm sorry, Zach. I'm sorry, hon. You've been ousted for somebody else. I ADHD, it is very chilling to hear the shh. And I teach American Sign Language once a week and on Mondays, and this woman has shh tattooed on her finger. So when she does this to her kids, it says shh. So correct me if I'm wrong. The video is coming in regarding the Sarah Boone and the victim. Is that correct? I want to say thank you for everybody for joining me today with the Sarah Boone trial and the Melody Walker Ferris trials. Yes, I am streaming 2 trials live right now. So thank you for your patience. Um, this is very intriguing, but I really, as much as I love all this lawyer stuff, I cannot wait to get in and start looking and listening in on the jury voir dires. Y'all, that's going to be awesome. Thank you. Feeling like this one scene. Yeah, I would love. Does anybody out there know anybody who does sound bites? Because I really would love to have somebody help me make some sound bites. And one of those is this really happening? I would love to get a sound bite of that. Sorry, guys, I'm rearranging my screen. There we go. We're all good now. I'm going to leave this going. I'm going to be right back. I've got to go to the other trial. We are still waiting. Now I can see. Morning, Sarah. Thank you so much for watching from work. Well, thank you for watching. I know, right, Case One? It's getting a little interesting. I hate having anything on my lenses. Drives me crazy. I know. I don't think they will. I think that they will understand all too well. I think the jury is going to be a little smarter than that. I think the only thing that's going to save her, truthfully, is procedural. So they did not toss out that evidence correct with the video. That is coming in. Once again, I'm bouncing between two trials right now. Honey Boo Boo, she should have taken that plea deal. I think her attorneys definitely informed her of that. Maybe not as bluntly as we do. It would. Especially since involuntary manslaughter is 15 years at best. They're going to buy into her lies. It's the only way they can properly defend her. Yeah, definitely ADHD. Y'all, I forgot. I want to share with you guys the fabulous sponsor that we have. It is the Hitchman Homestead Coffee Shooter Shack. They keep me going every day, and in the mornings they get me going. And I just want you guys to reach out and bless them as they have blessed us by sponsoring this live. Hey, y'all, please help me welcome the Hitchman Homestead Coffee. They are fabulous. They have many different blends of freshly roasted, freshly ground coffee. They have a monthly club where you get 4 bags for $40 or a Keurig option. Also, they just came out with a half and half. Oh my gosh, I absolutely love it. So do me a favor. Go down to the link below at hitchmanhomestead.com. Order you some coffee and show them some love. I also want to give a big shout out to our partner in crime and sponsor, As the Gavel Drops. If you love diving into court documents, reading things for yourself, doing research, go to Discord and go to As the Gavel Drops. Without them, we wouldn't have a lot of the documents that we have that we go through every case. So y'all, go join As the Gavel Drops, and remember, make sure you validate yourself. Y'all, I want to take a quick little break. I want you guys to go over to As the Gavel Drops. We thank them so much for not only partnering with us, but supporting us in what we do. If you're someone who absolutely loves to dive into court documents and read transcripts and motions and anything court related, go to Discord, link below, and go to As the Gavel Drops. Thank you for partnering with us, and thank you for supporting this channel. No problem, Case One. Thanks for hopping back in. We are on a short recess. They are moving to room 23, which is the upstairs, the old traditional, large, gorgeous courtroom, via what Jules has explained to us. And we will be back, and then they'll start jury selection again.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
William J.
Defense.
James Owens for Sarah Boone.
All right, Ms. Boone is seated at counsel's table wearing the same clothing from earlier this morning. All right, it is 11:24. With regard to the Richardson hearing with regard to item 6 in the defendant's fifth amended reciprocal discovery list, the court is going to reserve and have that hearing tomorrow morning at 9 a.m. Defense is to provide an edited version of only the records that pertain to anxiety or their lack of thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6 was cured by agreement.
Okay. Did that happen when I was not here?
No, it happened earlier while we were here.
And what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
Number 2 is the 119 new JPEG pages, according to be from Winter Park Advent Health, and they're a little bit different than the 81 pages that I previously received.
Okay.
She is looking rough this
So the
morning,
ruling
y'all.
remains the same. Court's going to reserve. Address the
Probably only
Richardson
had
hearing
3-4 hours
tomorrow.
sleep.
You were to provide an edited version of those records that you seek to offer into evidence. Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's response, those witnesses will be excluded if not deposed prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
All right, Judge, the same as should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
State response.
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, we've got a substitute analyst. So that's our reason for the late disclosure on her. And who were the other 2?
Michelle Fenner and Victoria Shelton.
And those are the 911 dispatchers.
Good morning, Ambrose Laura. Good morning.
That's fine. We will pay for the expedited transcripts, what I would expect.
You're so naughty.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Cacciatore does not believe that the defendant ever deposed that person.
Okay. Any other positions, Mr. Owens? Okay. All right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have that thing again, please? If you all still have yesterday's
What?
sheets from jury selection, Madam Clerk has advised that jury services has told us the juror in seat 25 wearing badge 63 called. The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any. So stipulated, juror number 25 wearing badge 63 will be struck for cause. We'll advise the jury services to call them and tell them they do not need to report. With regard to the order tennis motion as to Ms. Boone's request for snacks, the order tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23 at 1 p.m.?
Boone got
Defense?
denied her
All right,
snacks.
we'll see you all at 1 p.m. Thank you very much. Court's off the record.
Uh-oh, she just realized it. Sarah Boone aside, I am going to wrap up this other court. They are breaking for the day. I'll be right back. Whew, okay. Now I'm down to one live. Oh my gosh, y'all. I love being able to stream two court cases at once, but it is hard to bounce and keep up. Okay. Well, I forgot to take that banner down. We're going to put it back up. Court is in recess. I need to kind of figure out what happened. Mod, help. Her snacks were denied. I heard that. Well, here's the thing. What she wants is chocolate on the pillow when she gets back to her dorm at 9:00 at night, because after the court is over, she has time with her lawyers then to prep for tomorrow. So this is going to be fun. Now, they can feed her whatever is permitted. I mean, as long as they inspect the food, she can get snacks. She can get things from her attorneys while she's in the court. However, I know she's at least a size 10, at least. I am looking at Notorious Jules, her notes. I know she's going to run out and call. I'm going to try and get a hold of her at some point. Hey, love, how's it going today? I don't expect her to call back with me because I'm not I mean, RA is who she's going to be calling. So I'm going to put him over here and listen to what she has to say because this ought to be very good. Wait a minute, RA's doesn't even have her on. What? That doesn't make sense. Let me go over to Recovery Addict Live. Oh, there he is. Okay, looks like he's getting some information. So I guess they're gonna go over to Sarah Boone. Hey, yeah, I know, right? No, yes, she wanted candy, she wanted her chips, she wanted her Pop-Tart or mints and everything when she got back to her cell. Is this over? What? They ended the stream. Are you freaking kidding me? Okay, let's go back. Oh, joyful. So I think we have about an hour. They went for lunch. Um, so we're gonna wait and see. Her lawyer will take care of her. Yeah, they will feed and take care of her. She just wanted when she got back to her cell or her dorm on her bed, she wanted her commissary. And they're like, no. And part of that is it'll be stolen. So that means they would have to keep it up at the guard station and give it to her at night when she gets in, and that will cause a big disruption. Um, so she wanted to get back and have a munch party. Let's see. Judge reversed a ruling on Richardson hearing until reserved until 9 a.m. tomorrow morning. Last minute witness that has been deposed. Judge said that the defense has to pay for the transcripts. Juror 64 is not here due to taking care of an ill child, which we knew. Jules, you were absolutely phenomenal. She was released. And she ruled that she could not have snacks in the courtroom. What she wanted to do was wanted two things: get her snacks delivered, I mean, all of her commissary put on her bunk, and then she wanted to bring those to the courtroom to snack on. Oh, toxic. I like your thinking. Let me see if I can give her a call. She may not answer. I'm calling Miss Jules. Yep, no answer. I'm still like dying at Owen liking Boone to a dog talk. I found it interesting how chummy that Boone and the paralegal were getting. I'm catching up with Jules. Okay, I'm gonna read her comments from today. Good morning, good morning. These are all from Miss Jules. So let's just kind of read her caption from her Twitter account. Okay, Miss Jules says, "Good morning. I got less than 6 hours sleep. I'm ready to go. It seems like we're in for another long day of court. I believe there are 2 more motions, and then they'll continue the juror interviews." The other thing, the next one was we'll have to have a late start this morning. Judge Kirknick has 15 arraignments to do before final. Yep, that's true. We did start late. He's entered all right, Miss Sarah Boone entered in full shackles. They were moved, same suit as yesterday, but a pretty yellow blouse. Um, hmm, the blouse was pretty, but not for her. She happy she appears to be happy this morning. She is conversing with the entire team. Yeah, the makeup was indeed a no-no. George Kranick, sorry, is allowing prior bad acts of victim during trial in order to get that in. She must testify, and she is going to testify to any overt acts by the victim. So, if they wanna get in the victim's prior, acts and behavior and the BSS, she has to testify. They can't bring it in without her testimony. So, she's gonna testify pretty early in this case on the defense's side. She has 2 cups of water at the counsel table. I find it interesting that they're little cups, she cannot have a bottle. They're very controlling with what she can have, including the, rubber pen. Okay, so RA is getting off of his lives. Hi, Mary Kay. The Richards hearing is going on because the defense was to introduce evidence of Sarah Boone's injuries that she sustained during altercations with the victim. Well, those have not even been admitted yet. So that's why they wanted I think what's going to have to happen is it will come in if she testifies. And until then, it doesn't come in. Basically, they're going everything that we went over yesterday. The state said that the defense has not turned over to the state what Judge Kranick ordered yesterday. How am I not surprised? The state received 382 pages of jail records from Orange County Jail last night. State argues nothing in those pages are relevant. It's normal complaints of middle-aged woman. Oh, well, we've seen those behavioral notes, and we have all of them. The demands are Sarah Boone wanted hostile treat. The demands are Sarah Boone wanted holistic treatment in the jail for her ailments. Apparently, she made a lot of demands and complaints about the jail. State feels none of this is relevant. Mr. Owen argues that they are relevant. Judge asks, how is COVID test and other ailments of this nature relevant? Defense conceded not to enter the evidence as to delay the trial. Really? It's not relevant how many times she's had a cold, how many times she's had cramps. Body footage will be used only to refresh the officer's memory. No jailhouse calls to be used if I understand correctly, i.e., Notorious Jules. Will testify specific injuries from George, but there are no documentations, the state argues. Sarah Boone is staring forward, no expression. Mr. Owen says that Sarah Boone feels the state let her down because they didn't protect her on 3 occasions when George was arrested. Oh, boo, boo, hoo. You're the one that when he was arrested and then you cried to get him out. You can't have someone arrested and then you bail him out yourself. Brian Boone will testify for the state. Mr. Owen states that Brian Boone will be a hostile witness for the defense and his bias. He's biased. Mr. Owens said Mrs. Boone hasn't paid alimony. Mr. Boone hasn't paid alimony entire time Sarah Boone's been incarcerated. I need help from Law and Lumber on this. Is one obligated to pay support? Well, it depends. Yes and no. The alimony support. Sorry, Pupper's trying to get underneath the desk. There you go, baby girl. He can continue paying, and it's put in a trust. And then once, if she's found innocent, she can get it. But in some cases, no. It just depends. Sidebar, Sarah Boone is taking notes and speaking with her team members during the break. They are doing some giggles. It seems like they're getting along well with the female members. Yeah, we saw that. Apparently, the last objection was overruled at sidebar. Judge did not reveal anything else on that in particulars. Because I'm sitting so close to Sarah Boone today, I noticed that the writing instrument she is using is extremely tiny and thin. Yeah, we've discussed that. Okay, I'm going to take a comfort break and we'll be right back. Okay, I'm back. Come here, baby. She's not going to like me, y'all. I got to take care of her. Over here. Turn. Okay, baby. I know you're not going to like me. She's looking at me like, Mama, what the heck are you getting ready to do? Give me your ear. Just lay your head on my lap. So, as far as I'm concerned, Sarah Boone, they broke the mold with her. Does that feel good? Ooh, does that feel good? Oh, does that feel good? Most battered women do not call the police in fear and make it worse if someone. Yeah, and the other thing is that I feel, and I've not been in their shoes, okay, so I'm not being judgmental, but I've never understood why would you say, call the police, he's battering me, he's beating me up, doing all this stuff, and then you turn around and you bail him out. I know it's a mental problem. I mean, I'm not naive to that, but I have really struggled with that behavior. Never have understood it. Of course, I'm not judging. I've never been in that. Ooh, I know. Sensei, I got to get it. This dog is the most tolerable dog. Oh, I see it, baby. You've been scratching. Oh, honey. Oh, honey. My girl's ear is bothering her. Just making sure she's not getting an ear infection. But she does have a little sort in her ear, so I think she's been irritating it. The other ear looks really good. Really healthy. Sorry, I had to just get this dealt with because her ears are my ears, and I got to take care of her ears. And I have to tell you, this is one of the most patient dogs I've ever met in my life. I think part of that is the way she was raised in with the service dogs for the blind. One last time. Give me your head. Come on. Good girl. I know. But it's cool. It should feel good. It should feel nice and good. It's nice and cool. You're done? Oh, good girl. Smack that ear around. Urgh. Now I got to get rid of this. Oh. Hold on. By the way, this is one of the tumblers that you can choose. If you look close, it glows in the dark. It's got the little sparklies on it. Hopefully the cops will testify that George was each time he was ready. He was very compliant. George did not ever act out. George did not ever act out. I think that George, he was very compliant. He never seemed to be aggravated to the extent he never resisted. He was never disrespectful. I think he just trying to defend himself, and he shouldn't have did what he did, but he did. As far as if he laid a hand on her, but I tell you, man or woman, if you come whooping up on me, I'm going to defend myself. I don't care who you are. Okay, talk from experience. I can tell you this: they have you so broken down, you believe you cannot survive without them. We are so desperate to believe he wouldn't do it again, etc. I get that part. I do understand that. But you can't sit in a courtroom and say, I was terrified of him. He was arrested. Then the state didn't protect me from him, but yet I pulled him out of jail. I think the state did protect you from him because they put him in jail. And then you went and got him out. Oh, I'm sure he was. Oh, me too. I understand what you're saying, Toxic. I do. But those women aren't sitting in court for unaliving them and then turn around. My camera's crooked. And then turn around and say, oh, the court didn't protect me. Hi, Zach. Thank you so much, Zach. You're so awesome. You know what I'm saying? It's like she's saying the court did not protect me from him. I'm like, well, honey boo boo, you pulled him out of jail. Oh. Oh, you don't like Kenny G? Ooh. And that happens. The same reason why Toxic said. There was a restraining order. Yeah. So Boone is off the charts on that part. That's what, in order for her to sit there, the state didn't protect her. They would have to deny the protective orders. They would have to turn around and not arrest him. I mean, that's a lot there. And so I'm sitting here going, but they did. It was just you yourself chose to get him out of jail and bring him back into your home. Oh my God, Zach, you're so sweet. Zach. We're getting to know a little bit too much about you, my dear friend. No, I'm kidding. Have y'all noticed that Zach has never commented back to me about the fishing trip that we talked about one of the first times we met? And I said, I've never been night fishing and I want to go. Yeah, I seem to he never comments back on my fishing trip. Oh. Hey, I know a lot of men who are not that enjoy bubble baths. I mean, they can be really good for you. Heck, I have them every time I get a chance. I'm a bubble bath junkie. Bubble bath junkie. I guess I'm not going to be able to get a hold of Miss Jules. I have to be honest, my stomach is not happy today, y'all. So if I'm getting up for comfort breaks today, please be understanding. My tummy don't feel too good. That's why, oh my gosh, we had a Model T, a thing in town where all the Model Ts lined up and drove. Yesterday morning, I saw one, but this morning I saw a bunch of Model Ts as I came into work, and they're having a Model T antique car and parade. My gosh, I'm jealous. I wish I could go see them. I love old cars. I love their engines. Yeah. Yep. I love the Model Ts. They are so freaking awesome. Oh, excuse me. I have an itch. So one thing about domestic violence, it takes an average of 7-10 times to finally leave the abusive relationship, and most often than not. We think we love them and we cannot live without them. Yeah, that is so true. That is so true. Oh, how rude. I know, right? Yeah, I mean, we live in the same neck of the woods, right? And I'm so sorry, Mary Kay. Yeah, see, Zach still ain't commenting on that. Zach, you can politely say, ma'am, I'm sorry, you're not my cup of tea for a fishing partner. I just never been night fishing and I just kind of want to go. You know, I do understand the mentality as far as the victimhood and all of that. What I don't understand is the mentality of blaming the state for not protecting you when you are your own worst enemy. Yeah, like you were going to come visit me, Zach. You were going to come to the studio and sit behind the desk. Uh-huh. Heck, I'd meet you at the coast. As soon as I get my camping gear, I'll find a beach and camp out on the beach and go night fishing. Mm-hmm. I can't wait to get my camping gear. I've got to get my friend to help. I got to help my friend unload his Connex before we can get to some of it. But yeah, I really want to start getting out more, and I can't wait to get my camping gear all set up. Got to figure out how to fit it all in the car, though. Yeah, the service dog's gonna have to learn to ride up front. But she can. I'm just being facetious. But I am looking forward to next year of at least once every other month going and spending a weekend somewhere, getting out. I would like to do it once a month. Getting out, throwing up the tent, getting out in nature, fishing. I can hunt. I only hunt when I need the meat. Oh, that sucks, K-Swan. Oh, that royally sucks. Yeah, I need Zach to help me pick out a good fishing rod and equipment. I don't have anything anymore. I haven't had anything for years. I used to have some stuff, but like K-Swan, some of my stuff disappeared. Somebody thought they needed it more than me. I know, right? So everybody is kind of going off about how she can't have her snacks in the courtroom. Well, guess what? Neither can anybody else, my dear. Oh, I'm glad I didn't have to go up front. So anyway, I also do watercolor. I'm a watercolor artist, and I'd love to be able to just sit and do some watercolor outside. I also have my native flute. I just to walk and hike and just be out. I love what I do here, y'all, but I am in probably a 10 by 12 room, maybe a 12 by 14 something size room. It's like a cave, and I enjoy it, but I miss being outside too. Just depends what mood I'm in. In the moon, ba-da. Zach, favorite place on the coast to fish? Oh, that's fighting words. You still upset about that, huh? Yep. That would make me angry. That would make me raging angry. Raging. Mhm. Did you report it, my dear friend? Hence why you should have cameras all around your property. In fact, I'm going to get a hunting camera so I can put it on a tree or around my tent. Shamrock Cove, Pelican Island, and Corpus Christi Bay are over by the lighthouse. Good to know. Good to know. I love to watercolor lighthouses. My father was in the Coast Guard, and one of the things he loved is lighthouses, and we shared that love. I think at one point he tended a lighthouse. Oh, that's even worse is when you got old inherited lures. Oh, that sucks. Sorry, K-Swan. So, I have a love for lighthouses. I'm not a beach person in general, and you won't get me way out in the ocean. I've been in the ocean, like out a couple of dunes, and I was with somebody. They were fishing, my significant other, and it was the first time I was in the ocean, and probably the last time I was in the ocean that far, other than ankle deep. And it looked like this huge jellyfish about the size of my room. It was at least 8 feet across. It was huge. And it was coming up on a wave. And when the wave came up, and it was probably about 20, 30 yards out. And the wave came up, you could see it, and it was like a rainbowy looking thing. And I told him, "Hey, look pretty." And he just grabbed me and said, "Swim." And he dropped his pole, which was tethered to him, and we started swimming directly parallel. And it passed me, and he told me it would have killed me. What would that have been, Zach? A jellyfish that big? It's not a man of war, is it? Manta ray? Oh, I'm sorry, K-Swan. Sensei, your ear's still bothering you, baby girl. Come here. Come on. I know you're going to slap it around a few days. Come on, please. No? Okay. Oh, poor baby. I bet that hurt. So when I go camping, I've decided, especially if I'm alone, but even if I'm not, I'm going to get one of those, what I call hunting cameras, and I'm going to hide it in a tree nearby and have it facing the camp, just in case. You never know. Could be a bear, could be a critter, could be a human. Chances are they didn't, and they sold what they thought they could get money for and dumped the rest. And that's the sad thing. That's where it gets sad, is that, it may not be very valuable for money, but the sentimental value is far more important, and they don't realize. Oh, they do. They just don't care. They do. They just don't care. The execution of Texas inmate scheduled for today now in question after he called to testify before the state committee. Oh, all right, this is what's going on in my neck of the woods, okay? In my neck of the woods. In Texas, barring intervention by the courts or the governor, Texas on Thursday is scheduled to execute a death row inmate, Robert Robertson, who claimed he was wrongfully convicted of abusing 2-year-old daughter until she passed. But the statute of execution process is now unclear after an extraordinary decision by the Texas House Committee Wednesday night to subpoena Robertson to testify as it reconsiders the lawfulness of his conviction. What? The extraordinary and unprecedented maneuver reflects how the seriously Texas legislature have evaluated the concerns of Mr. Robertson's case. Robin Maher, executive director of the Death Penalty Information Center, told CNN of the decision. They are also sending an urgent public message to the governor, Greg Abbott, that they, like so many others, do not believe Mr. Robinson be executed. The Texas Department of Criminal Justice have not announced whether Robinson's execution will be delayed due to the subpoena from Texas Committee on Criminal Justice Prudence, which is called for Robinson to testify on October 21st. The department said Wednesday night that it was discussing appropriate next steps, which the state attorney general's office. If he is put to death, Robinson's attorney said he will be the first person in the U.S. executed for conviction that relied on allegations of shaken baby syndrome, A misdiagnosis in Robertson's case, they argue, and one they say has been discredited. Wow. Good evening, Haley Mouse. Oh, y'all, I got to keep an eye on this case. Got to keep an eye on this case. Nothing I'll air here because it won't be live. But, oh, RA did it. Sarah Boone, he's got, RA has these coolest thumbnails. I love his. I thought about doing it, but I said, nah, let him have it. Other people kind of copy him. But he's got the suitcase, the baseball bat, the wine bottles, 2 fingers sticking out. Sarah, I can't breathe. The copy of the advertisement, the dartboard, the arts, crafts. Oh my gosh, y'all. I'll share it. Look at his thumbnail, y'all. Y'all. Look at that. That is too cute. Oh, look at the heart puzzle. The heart puzzle. Her letters, the paint, the wine, the darts. He's going to have a counter box up here. Sarah, I can't breathe. I can't see what's under the notify me. Looks like the cell phone. But the 2 fingers, oh my gosh, that cracks me up. Yeah, y'all, that's cute. That is stinking cute. Yes, George was an artist, Haley Mouse. He was a good artist. Oh God, what was George's last name? I'm pulling a blank. Jorge Torres Jr. Let me see if I can find some of his artwork and see what he did. See if I can find some of his artwork. If anybody else wants to try, because I'm not having any luck. Let me try this way. Some of his artwork for sale. I'm not. All right, we'll show. Okay, there's that. That's his. Not bad. There's some more. I saw some more. Okay, let me do it this way. That's his. I'm just perplexed with the sewing machine, the bicycle, and dog. So there must be some kind of importance. Question. Remember, Brian said he bought Sarah out in the home he was living in, and then I heard he was in foreclosure later on. Is that correct? No, she was in foreclosure. He bought her out of her part of the home. Yes. And then he ended up in foreclosure. But they both have a foreclosure on them, if I am remembering correctly. Is this the same Jorge Torres? No, not the same. I don't see a lot of artwork for him. Let's look at this. Let's see if we can find anything else. This is interesting. He's into sewing machines. Have you noticed that the two of the pictures have the sewing machine? That's, I mean, and this I think is the most interesting part. I think if you just cut that face out, that in and of itself is great. The other stuff, not too sure why you have it. He was okay. He wasn't fabulous, but he was okay. He had his own style, not knocking it. Here's another one. See, once again, sewing machine. So for some reason, sewing machines are very important to him. Yeah, they're decent. I just want to know the story behind the sewing machines. Why sewing machines? They've been in every image that we've seen of his work. Well, no, not this. I like this. This is interesting. That veil work, that is hard to do. That is some skill right there. That's some skill right there. I'll give him that. That's definitely. Is that his? It may be. See, that's interesting. Not my cup of tea, but interesting. Yes, he does. I don't see anything else. I don't believe this is his. No, no signature. Could be wrong. I'm still looking. Oh, his obituary cover. Oh, his obituary, y'all. I got his obituary. With heavy hearts, we announce the death of George Jr. Orlando, born in Philadelphia, Pennsylvania, passed away February 24th of 2020 at the age of 42. Family and friends are welcome to send flowers or leave their condolences in the memorial page. Share them with the family. He is survived by his parents, Jorge Torres Sr. and Belanca, his children, Anna and George and Destiny. Siblings. Aww. Well, wow. Maybe his mama was a seamstress. I think she was, actually. Come to think of it. Only 2 people left messages? I'm very sorry to hear this. Oh, nobody left messages. That's sad. Oh, I kind of want to leave a message, but don't know them. Oh, that's crushing. That's crushing, y'all. Ooh, now I'm sad. I'm really sad now, y'all. That's so sad. That creepy sad. Okay, here we go.
Tony Dickerson for Sarah Boone.
That's so
Ms. Boone
sad.
is seated at council's
I
table
know
wearing
that's
the same
horrible, but
clothing
I'm
from
like,
earlier this morning.
that
All
bummed
right,
me
it
out.
is 11:24. With regard to the Richardson hearing with regard to item 6 in the defendant's fifth amended reciprocal discovery list, the court is going to reserve and have that hearing tomorrow morning at 9 a.m. Defense is to provide an edited version of only the records that pertain to anxiety.
I don't know
or
if
their
it is
lack
his or not. Like I
thereof
said,
to
I
the
wasn't
state
sure.
before
I
9
wasn't
a.m.
sure.
tomorrow morning.
Judge, number 6 was cleared by
But that's all I could find. Most likely may not be his.
Okay.
I
That
hope
happened
y'all
when I
heard
was
me
not here?
say that.
No, it happened earlier while we were here.
Then what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
Number 2 is the 119 new JPEG pages, according to be from Winter Park Advent Health, and they're a little bit.
Did we lose you, Zach?
81 pages I previously.
Did I run you off?
So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow, and you were to provide an edited version of those records that you seek to offer into evidence. Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's response, those witnesses will be excluded if not deposed prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
All right, Judge, the same as should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
Okay, response?
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, we got a substitute analyst. So that's our reason for the late disclosure on her. And who were the other 2?
Michelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will pay for the expedited transcripts. What I would expect will not be lengthy nor expensive.
What's
Okay.
going on with the mic?
Has the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Cacciatore does not believe that the defendant ever deposed that.
Okay. Any other positions, Mr. Owens? Okay, all right. State will afford the same opportunity to the defense. as provided
Okay.
by
Thanks,
the
Haley
state
Mouse.
To the defense. Court's
Yeah.
going to be in recess.
Oh, well.
11:27. Hang on.
What?
Juror number. Yes, let me address that. Can I have the thing again, please?
Okay, that ended. Why are they cutting the court feed? Why? The court feed was cut. Don't get it. Trying to find it. Look, y'all, we've hit 90,000 views. We're going to have a party when we hit the 100,000. That'll be cool. Okay, let me biggen this. Go back to. Okay, we're in. But I don't know if they're going to have, I don't know if they're going to have the caption. So let me get one lined up just in case. I have to have captioning if I can. Uh, okay, we'll just wait. Do you think those of y'all who've been watching the Melody Ferris trial, do you think her boyfriend helped or burned her? Yeah, but to what time? You said 11:27. Did he mean 12:27? Either way. Yeah. Mm, yeah, I agree. So, watching out for stuff from Miss Jules. She's so awesome. Oh, that's what I wanted to do. I wanted to see if they had anything during the break on Trial TV Live. Ah, that's what I want. See if they had anything live during the break. That would have been great. I don't see anything. I don't see anything. I was hoping they'd have I thought they were going to go live during the lunch break, but I guess they did not. Dagnabbit. I was hoping they would. Nope. I kind of think he sold her out too. I think that he's definitely in it to save himself in the Melody Ferris murder trial. I think on one hand he was trying to help her in the very beginning, but then when he was served with the subpoena that had not been signed, I mean not a subpoena, a warrant that had yet to be signed, but was prepared to go to the judge and be signed. It does not shock me. Does not shock me at all. I don't know why we're running slow, but we are. But it does not shock me at all that he would throw her under the bus. Yeah, it's 11:26 here, so any minute now they'll come back. And I think they were going to be in room 23 this time because I'm wanting the voir dires. I want to listen. I want to listen. I want to hear what questions the defense throws. I want to know. I want to know. Okay, guys, let's do this. I have nothing to drink. I need to go get a drink. I'll be right back. It'll just be a minute. Everybody take a comfort break and stretch so we can get ready for the rest of the afternoon. I wasn't sure they'd come back before I did. I had to go get me a drink. If you guys are ever in Kerrville, Texas, in the Hill Country, go to Classic Hamburgers. They're so freaking good. Well, but I haven't heard from her. I haven't seen her. That's the problem. But that's interesting. I guess she's not. I'm going to subscribe to him. I never have. What do you think about the guy that fled Kerrville police to Fredericksburg and got... Craig, what? What do you think about the guy that fled Kerrville police to Fredericksburg and got permanently stopped? You mean unalived? You mean unalived? When did this happen? I've not been on call, so when I'm not on call, I don't know what's going on. When did this happen? I haven't had my radio. 1 minute ago? What? I should have had my radio on.
Spanning 2 counties in the Hill Country ended in a police shooting and the suspect killed. Kerrville police say just after 1 a.m., an officer spotted a driver committing multiple violations, tried to pull them over, and that's when the driver sped off. Gillespie County deputies and Fredericksburg police joined when the chase crossed into their jurisdictions. Investigators say the driver ended up losing control and crashing off of State Highway 16 in Fredericksburg. Now, police say the driver then got out of the car and charged at the Kerrville officer, and that's when that officer opened fire, killing the man. Investigators have not identified that man, and they have not said if he had a weapon. Kerrville police say the officer is on paid administrative leave while the Texas Rangers investigate.
9
There
out of
you
10
go.
people
There you
won't
have it.
answer an unknown caller. Inform branded calling from...
Wow, I'll have to follow this. See, for the last couple of nights, we have not left this area. I mean, my office until midnight, 1 a.m. So this happened yesterday. Yeah. Wow. Dang. Thank you for telling me. Interesting to know. Well, I mean, if he pulled out a gun to shoot at the police and the police shot him back, apparently he had a weapon, dude. That was kind of strange reporting right there. Oh, wow. Interesting. Thank you. Craig, do I know you, love? Yeah, it's been 2 or 3, this is the 3rd night I've not left the studio. I've been up here after midnight. And then I'm up here late because I'm going to college. For those of you who don't know, yes, I'm deaf and I'm going to college and I'm doing this. Joel from Surviving the Survivor. So, yeah, I've been a little behind the ball, but I remember not last night, but the night before last, we had a lot of cops coming in from I-10. So that was probably closer to 2 almost. Yeah, that probably was them coming back. And then last night, when I was heading home at 1-ish in the morning, a little after 1, um, we had a lot of police cars coming from the Ingram Hunt direction. Yeah, now they're going back at 1, so it's okay. We'll be here. Okay. Thank you, Haley Mouse. Yeah, I've got um Miss Notorious up, and then I'll put him up too. I can do both since I don't have 2 lives going right now. But yeah, it's Kerrville just a few years ago, you would have never had this much activity. And yet we do this year. The last couple of years, it's gotten pretty busy around here, don't you think? Craig? Yep. Survivor the Survivor podcast. Oh, they're all at a restaurant across the street from the courthouse. This trial smells disastrous. I hope I'm wrong. 2 prosecutors is having an intense conversation at lunch. I bet they are having an intense conversation at lunch. I bet. This state is now reading audio from Notorious suitcase videos. Sarah Boone's was staring daggers into the prosecutor, Will J. Defense has their heads up. Their heads are on a swivel. Yeah.
Just don't understand how they know they do not have a jury, and that's why I don't understand how they plan to have opening statements. Both the defense indicated it was going to happen this afternoon, and the state mentioned it to the judge as well regarding opening statements this afternoon. So I just don't see how, because there's still 50 plus jurors that they have to go through and whittle that down to 6 regular jurors. Keep in mind, remember, it is a 6-panel jury. I never got word. No one seems to really know about the snacks motion. I will get
No
official
snacky.
confirmation of
No
that. And I will
snacky,
tweet it
snacky.
out at podcast STS.
No
I will
snacky.
personally ask their defense team. I took the elevator down today with I can't remember his name, so forgive me, but he is the 3rd chair. He's basically retired counsel from Florida. He lives in New Mexico. He came out of retirement. He told me for this very trial, and
I'm so sorry, honey
he
boo
rolled his
boo.
eyes saying, like, what have I gotten myself into?
I'm
So
sure.
that's a little behind the scenes. And people on the elevator had a laugh. Snacks were denied, according to Christy. Good to know. Judge denied it for best. So you guys, this is like, I'll make the analogy. This is like going to a baseball game in person or a sporting event in person, as opposed to watching it on TV. There's so much going on in the courtroom and so much being said and so many side conversations that I'm paying attention to that it's hard to get some of the particulars. But SCS Nation, of course, is always on it. So thank you for that. I am just taking a look at my notes. So we got a glimpse into the defense today, which is important. Basically, they got up there and said, look, they felt like their hand was forced a little bit because there's this ongoing issue about the battered spouse defense. So James Owens got up there and said, look, Sarah Boone, she had nowhere else to turn. This is verbatim. She had no family to go to. She felt helpless. He went on to say that the defense expert doctors are going to corroborate all this. Well, I sit in the camera's view. I don't know. I probably can't because I'm in the jury box. So once the trial starts, you'll see me in the gallery, I am sure. So long story short, they showed some of their hand. It looks like they are moving forward with this battered spouse defense. State has taken great objection to it, and the judge indicated yesterday he's going to allow parts of it in, and some parts of it will be denied. But a lot of that discussion continued in this morning's motion hearing. Now, the state's case, Will J got up there and said, basically, what he did was, no, Sarah's getting up for the judge. She has to, so she's getting up. I have not seen her not get up. Will J with the state got up and began reading a transcript from the suitcase video, what Sarah Boone was saying to Jorge Torres as he was dying and suffocating in that suitcase. At that moment in time when Will J was doing this, Sarah Boone was literally shooting daggers from her eyes into the back
I'm
of
sure
Will
she
J.
was.
She did not like hearing her words being read aloud in the courtroom, but you better get used to it. Once the state finished reading all of that, which was Sarah, please help, Sarah, I can't breathe, went on for quite some time. He mentioned the 2-minute video and then another video, I think it's like 37 seconds of just the suitcase, and said that
No problem, just
was
checking in
essentially
on
their
you.
case. The quote is,
Been watching
that
you
is our
every
case.
night.
This
I'm
shows
proud
her
of you.
depraved mind.
Period.
And then went on to say she had utter disregard for Jorge Torres's life. Adding on to that, Will J, the state prosecutor, said, we also have new statements, and this is what's come out recently. He said they know that Sarah Boone shook the suitcase violently, hit it with a bat, including taking swings at Jorge Torres's fingers, and then tossed it down the stairs. You'll recall there was a neighbor who said he heard a thumping sound. Once this was all done, the defense got up and they've kind of been taking shots at each other about discovery, about this evidence. And James Owens at that point said, I wish I had this all in writing weeks ago. And he says he fully does not agree with that. It is a bone-chilling transcript. Essentially, the defense says that they do not agree at all, which is no surprise with the state's defense that she has this depraved mind and utter disregard for human life. James Owens then went on to say that the state tried to reject this battered spouse defense twice. And because of this, again, he was griping that it forced the defense to reveal the overt act. Now, I'm no lawyer, but I play one on YouTube sometimes. I love having lawyers around me, so I don't have to do this. But as a reporter, you catch on to things pretty quickly. And from what I understand, in order for the battered spouse defense to be invoked and used in this trial, there has got to legally be an overt act, meaning that she was scared for her life and had to respond. Now, we all know Jorge Torres was zipped into a suitcase and was defenseless. So the defense said that they were forced to reveal that a couple of Jorge Torres's fingers were sticking out of the suitcase. That is going to be the overt act that they bring in this trial, which sounds ludicrous, and in my opinion, this is just an opinion, is completely ludicrous. I mean, just picture it. If you've seen the suitcase video, you can't really, in that video, I don't think you can see the fingers, but just imagine the defense saying that because 2 fingers or 3 fingers were sticking out, which, by the way, she was whacking with a bat. Because of that, she feared for her life and just left them in there. Seems very far reaching.
It is.
The judge barked back at James Owens, saying that no one was forced to reveal that overt act. Then James Owens, the defense attorney, invoked the 6th Amendment, saying that, essentially wondering if his defendant's rights were compromised in any way. Owens again repeating that he felt forced to show his hand. And then he then called out the state. I mean, he's doing his job. He's definitely doing his job. But he called out the state and said, look, they are charging her. She's charged with second-degree manslaughter in this case, but we have no idea why the state believes this. We don't know why they're bringing these charges still, and the trial is starting. So it was dramatic. It was tense. You could cut the tension with a knife. I do have to say that I feel my gut instinct, my visceral instinct. Why do they seem to be trying the case ahead of time? It's interesting. I mean, there's obviously no jury in there, but they're making their motions, and they're revealing a lot of what their strategies are going to be on both sides. I have this gut and visceral feeling that this is going to end in utter disaster. I don't know how, but, you know, the defense, obviously, this is her 9th attorney. They just got on the case 45 days ago. There's mounds and piles of evidence for the last 4+ years. There's no way the defense could have, in my opinion, properly vetted all this. Are there tons of fans? No, very few. This has been my experience. I think once opening statements start and there's testimony ongoing, there'll be more and more people in that gallery. But right now, it is very sparse, just a handful of people. This court is resuming at 1 p.m. in an hour and 4 minutes. In between then and now, yours truly is going to grab a bite to eat, so I'm not grumpy. By the way, we're doing a full recap show today, I believe at 5:30 p.m. The COE is going to post that, and so I don't think she has it up yet, but it will be up for 5:30 this afternoon, assuming court is over by then, and I'm able to get back to my room at the hotel in time. That's what we've been doing the last couple of days. Something that's super interesting to me in this is that, for all intents and purposes, it has been 100% revealed and pretty much confirmed that Sarah Boone will take the stand in this case. She has to give a reason that they can move forward with this battered spouse defense. No family for Sarah, no family for George that we're aware of. So
I'd pay to see
when
that.
Sarah Boone goes and takes the stand,
49.
she's going to deliver what is known as narrative testimony. This means that her defense counsel, James Owens, cannot ask questions of her. She has changed her story so many times that there is the real possibility that James Owens himself, the defense attorney, could perjure himself with questions because these stories have changed so many times. So she's just going to get up there
on your bingo card.
And this scares me to no end, because I feel like she could talk for many, many, many minutes, hours,
days,
potentially days. I don't know if there's a cap on it. The judge will put a cap on it. I just, after having watched her, and maybe I am completely wrong. Maybe she'll be super coherent. Listen, I don't have any doubt that she's actually,
I don't think she could be coherent that long.
She's just a little out there, and definitely has an element of ADHD. I saw her sit still for about a minute today. That's the longest I've seen her sit still. So,
anybody want to make bingo
narrative
card?
Testimony is going to move forward.
Anybody want to make
really
a bingo card for me?
The wind is really blowing here, so I apologize if I'm crackling a little bit. Again, opening statements this afternoon. One thing that was interesting to me, Sarah Boone was doing a lot of note-taking. I was on Court TV last night, COE. I couldn't get my camera working, and we'll need your help with that. I have no idea how to eliminate a pop-up blocker, and I think that was the problem, but I digress. But yesterday, I was on with Dave Arenberg to discuss Sarah Boone, and it was interesting because he was talking about the snacks motion, and he said at the end, it is the diet of basically a school child, which got me thinking, and it's not rocket science, but Sarah Boone is definitely no COVID outbreaks that we have gotten yet, but the prospective jurors are coming in at 1 p.m. This is going to be at the top floor. You can sort of see the building behind me, even though it's washed out a bit. It's the penthouse courthouse for this afternoon. But going back to Dave Arenberg's comment about it being a a school child's diet. Two things. I was a little embarrassed because I do have a slight addiction to Reese's peanut butter cups and Twix. I won't
Shoot,
say that I
Craig.
didn't have a giant 4-pack of a Twix last night. Before
Craig,
I went to
I'm going to
bed.
give you my
I won't say
Discord.
that
Can
I
you
did.
meet
I
me
won't
over
say that
in
I
my
didn't.
Discord, please?
So then I felt a little
Do you have
humiliated
Discord?
that I might be akin to Sarah Boone. Hopefully not too much. But the reason I bring this all up is as I walked by, did anyone notice how many times she looked at the camera today? She was out of control and loves the attention. She cannot control herself. It's interesting because I'm kind of near the camera. I'm between her and the camera. So she's staring over, looks like she's staring at you, but she's definitely staring at the camera. At one time, though, we definitely locked eyes.
There's
and
my
that was
Discord.
a little bit creepy. But my observation, walking back in from a bathroom break, she is at her desk and she had a bunch of notes piled on top of each other, but the top page looked almost exactly like her flyer, her request for an attorney. You
What?
all saw that. It looked a little bit deranged. It was highlighted and bolded and looked pretty wacky. Why do they seem? Yeah, I think it's just because these motions have come up, Annie K, and so they are having to show their hand to explain things to the judge, and that's also one of the issues is that they are showing their hand, which they didn't want to do. So again, I'm just getting the feeling from right now, this perspective from the early days, that's not going to end well. But back to the notes for a minute, they looked pretty crazy, for lack of a better term. And at the very top on the left-hand corner, with a pen, it said important, exclamation mark, exclamation mark, exclamation mark. And it was gone over so many times that it was like the boldness font here, I don't know, would be like a 20, but it was incredibly bold, which I could just picture her. I didn't see her doing this, but she just had to go over each letter a gazillion times to get to the point to make it as bold as she did. The word was
Wow.
important, and then below was basically chicken scratch that I couldn't read, but these were obviously notes that she felt were important. Again, battered spouse was the theme of the day once again. It was made known by the judge that when self-defense is raised, character evidence can be admitted. So when self-defense is raised, character evidence is admitted. So they could bring in people to talk about Sarah Boone's character, but only if there's an overt act. Only if there's an overt act. Again, that overt act is said to be the fact that Jorge Torres stuck his fingers out of the suitcase. The defense had no objection to this by the judge. The defense made it clear that a possible self-defense claim would come from Sarah Boone herself. And that is why everyone believes that we will see Sarah Boone. With that in mind, battered spouse cannot be brought in until this overt act is known. But in opening statements, and this came up again yesterday, in opening statements yesterday, in the motions hearing yesterday, Judge Kranick made it very clear that they can mention battered spouse in opening statements. So you should very well expect to hear that in openings. If they happen today from the defense, you will hear the phrase battered spouse or battered partner, whichever which way they decide to describe it. They discussed a lot of the exhibit lists. It was all numbers, 31A, 27B, all these different items from the exhibit list. The state then taking a shot again at the defense, saying that they have not received some of these exhibits and are in the dark. Then talked about the 550 pages of medical documents. This is something that came up
That's
2 days
overkill.
ago. That prior evening, Will J. with the state said he got this document dump. He went on to basically imply that the defense is sloppy and disorganized because he said he has since gotten a document, and it was this morning, but it wasn't a cohesive document. He said he got 115 separate JPEGs from the defense instead of a single clear document, and described the JPEGs as being upside down and sideways. You can tell that the state and Will
Irritating
J
as
was
hell.
annoyed with the way the defense is handing over things to him for review. Then there was then
And rightfully so.
an indication that there would be a Richardson hearing, and a Richardson hearing
For
is
her.
about possible discovery violation. So there's undeniably this tension between the state and the defense. Is defense handing over what they have? Is the state handing over what it has? More of it coming from the state to the defense than the defense to the state. Then we find out that on top of this 550 pages, those primarily relate to Jorge Torres. There's an additional 119 pages of medical records for Sarah Boone from the jail. And the state got up and said, we only have 81 pages of the 119. They were able to review them and said that, oh, I'm sorry, these are separate. These are just medical records for Sarah Boone. These are not the jail records. So my apologies. So there are 119 pages of new Sarah Boone medical records. The state says they only have 81 of them. It is clear that there are more. The defense says they simply don't have those because they haven't received them from the medical offices. So there's that issue. Then onto the jail records. Last night, the state, and this is why I think this is going to end in disaster. Just last night, the state says it received an additional 382 pages. 382 pages. This is just one little thing. 382 pages. And opening statements are allegedly starting today. How? I don't know. But the state got these 382 pages of jail records. Per the state, per Will J, fewer than 5% related to Sarah Boone's mental health. The state said to the judge, we're having difficulty figuring out. It feels like Alaska here, Neil. I don't deal with cold, and I think it's probably below 70 in the shade. 75 in the sun, below 70 here in the shade, and it's unbearable for me. I don't know how else to put it. Less than 5% of the jail records pertain to Sarah Boone's mental health, which is what both parties are really interested in examining. But the state said that they're having a real hard time figuring out why any of the other part would be relevant. Part of what we learned from these jail records, and it was a little interesting, Sarah Boone wanted only holistic medicine in the jail, meaning stuff from the earth, from nature, no typical pharmaceutical medications. She also requested, this is interesting, that she not be housed alone. Man, I'm feeling for those other inmates at the Orange County jail. She wants to be with people because she likes to talk. And not surprisingly, it was also revealed in these jail records that she suffers from anxiety. The state went on to say, look, by putting in all of these pages, it is frankly embarrassing to the defendant and frankly just irrelevant. James Owens' defense then hopped up and said the anxiety was not necessarily pre-existing, which is how it was indicated. That Sarah
Craig,
Boone may have grown
you can go up
in jail, implying that this might be a result of
and
battered
private
spouse
message
syndrome. Judge Kranick was still questioning the relevance. The bottom line
Or
for the
members
state
only.
is they said they don't want to bog
Members
the
chat
jury
is
down
fine.
with unnecessary paperwork. Then came in issues about body cam footage. No one had an issue with using body cam footage. The defense said, look, police reports might be needed just to refresh the recollection from law enforcement. No one had a problem with that. No jail calls are going to be introduced. No prior criminal history will be admitted other than what Sarah Boone will testify to. And this is what scares me. Again, she's giving narrative testimony, which means she's literally just doing what I'm doing right now, speaking straight, sometimes making sense, sometimes not making any sense. And so if she happens to trip up and mention something about something in the past, well, then it becomes open fodder for the state. But unless that happens, no prior criminal history will come in. As far as prior criminal history, the state also said that they had some serious hearsay concerns, that it would just be word of mouth and not actual fact or evidence. One last thing. Sarah Boone has an ex-husband that came to her home the night that Jorge Torres died in that suitcase. She called him before she called 911. Well, they've also had a little bit of a contentious divorce. Brian Boone is set to be a witness for the state. However, the defense said that they could call him too. But then the defense noted that Brian Boone has not himself complied with some court orders, specifically saying that he has not paid, let's put it this way, he has not paid alimony since Sarah Boone has been in jail.
Why
there's
should he?
ongoing litigation regarding this, and that Brian Boone has an attorney for this matter, but Sarah
Why
Boone
should
does
he?
not.
She's
James
in
Owen
jail.
stood up and said he's going to be an adversarial witness because he's biased. Look, he's not paying alimony. He wants custody of his child. He has custody of his child. He said he has taken the child, he said this in open court, to Gainesville to live with him full time. The state objected, saying this is ongoing litigation, and he fully understood. Will J said this, the prosecutor, I fully understand why someone would not want to pay alimony to someone in jail because they're in jail. So these were all the arguments that and topics that came up just this morning at 1 o'clock.
Okay, here's the thing though. He may not be paying it, but he will still owe it if she is found innocent and does not go to jail. Okay? Now, if she should go to jail permanently, then he can petition the courts and get that waived. But that to me is not a big deal. I mean, her and no offense, George, you're deceased, milked him, primarily her. And he's paid his dues.
On the dot in the penthouse courthouse on the 23rd floor. They're going to continue jury selection. I believe there are 53 prospective jurors left. My question, and the defense has to do their part, dear, how are they going to whittle this down unless both sides seem to know which jurors they want already? How are they going to whittle this down so fast as to have opening statements today? I have no idea. Jenny Allison, again, since they're having the Richardson hearing tomorrow, do you think they won't be able to start? That's another issue. I don't know. I'm not a lawyer, so I really don't know the answer. We'll discuss it tonight, obviously. On the panel, we've got Orlando attorney Brian Vesio returning, as well as a professor, Joe Patuto. If, by the way, you missed our show last night, there was some big breaking news with Charlie Adelson. He did not file an appeal, but there was a motion filed for an evidentiary hearing before any appeal would be filed. You can go back and watch that, and we will return to cover that as well. Some people are saying it's a massive bombshell, huge issue in the Charlie Adelson trial. Other potential retrial. Others are saying it's a nothing burger. Again, I'm not an attorney, so we're gonna have to wait for the process to play out. But once again, coming to you live from the Orange County Courthouse in Orlando,
Go take
Florida,
a break, sir.
at the trial for Sarah Boone. I'm going to go grab a bite to eat with your permission and the COE's
Not always, Ronnie.
permission. We will do a full wrap-up show at 5:30 p.m. Eastern Time. The COE will get that set up. Just a little bit of foreknowledge about how this is going to all play out. Tomorrow, I'll be back and forth for the morning session. Then I have to get back to Miami. The COE will take the reins and do a PM show on all of tomorrow's events. I'll try to stay in court tomorrow as long as possible. If it turns out that opening statements will not be till tomorrow afternoon, for some reason, I will be there for opening statements. I'm not leaving before opening statements. So love you all. Love you, Orlando. And we will see you on the flip side. I'll be.
That's wonderful. I appreciate him and I give him credit. That is Surviving the Survivor on X. Y'all can go to Twitter if you'd like. X, whatever you want to call it. Let's see if I did get a thing from Jules saying, quite busy. I'm like, yeah, no problem. Just checking in on you. I know it was a quite busy of a day. Notorious Jules. Wow, y'all. Her numbers are going. Okay, 8 minutes ago. Afternoon session for Sarah Boone was starting momentarily. Counsel for both sides is here, waiting for the judge. Hopefully, the jury will be impaneled today. Well, how do I put this? And generally, it is still owed, but he can get an attorney, go to the judge, and they can file a motion. They can do things to pause the money. She cannot, but here's the other problem, y'all. Here's the other problem. And listen, there is a maximum amount of money you can have in commissary for most places. I'm not sure where she is, but most places have a maximum dollar amount. Say he's paying her $1,500 a month in alimony, and the maximum amount is $300 a month. Where's the rest of that $1,200 going to go? I don't know. I think he has. I think he has a right to get his attorney, and he may be doing this under attorney's advice. I don't know. I'm not a lawyer. I've known somebody in this neck of the woods that had a spouse that went to prison, and they did not have to continue alimony. What they had to do, though, was make sure the money was set aside for the alimony should the person, if and when the person got out of jail, if that was the case. So sorry, communicating with Craig. He used to live in Fredericksburg, but he lives in a nearby town now. And we're chatting back and forth. So yeah, she does. She has somebody actually set up like a GoFundMe, but it wasn't a GoFundMe. I don't know. I don't know. But y'all, to me, if you were in jail under murder charges and he's taking care of the child, it was a fundly account. Do we know how much she raised? Being sarcastic. Yes, Toy, you're correct. But here's the thing. Part of the alimony may have been some child support. I don't know. They may have rolled it all together. I've seen that happen before. And if he's taking care of the child and she's not, she doesn't need it. Just saying. Just saying. But I could be wrong. Oh, you're being silly with the Wade reference. Yeah. Okay. Well, we are waiting on the judge. Something happened. Sometimes things happen. I got a weird smell coming into my shop today. Wonder if it's the heater. Something in my office doesn't smell. You were so right, K-Swan. Still no feed, guys. Alimony is support. I know it's a support of her lifestyle, but they were married. She no longer has a lifestyle. She has an orange. It's a new black style. That's true too. I mean, she's not paying rent. A part of all that spousal support is because of rent and utilities where she lives. She doesn't have the need for it other than her defense fund. And she's getting that pro bono. So what does she need it for other than extra commissary that she can use to fraud people with? Oh, I forgot you guys can hear me. Click, 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 click. I'm sorry. So, sorry about that. I'm communicating with Craig. There's a case here in San Antonio that's made national news of a missing woman. I will be following that when we get more information. I know the alternate juror or the 13th juror, excuse me, has already started following that, but I've got 2 trials on my boat right now. So once these 2 trials are over, we're going to dive into that one. It's in my area. Depending on what happens and if it goes to trial, that is a trial I will highly consider going to or sending somebody local to. I will. Because that will be one in my neck of the woods. That will be awesome news. And I can be a Miss Jules. And go live in the afternoons. The problem is I wonder if I can request an interpreter. Probably not. I'd have to have one go with me. Just saying. Okay, Surviving the Survivor took the elevator up with Sarah Boone's attorney, Tony Henderson. He told me he thinks it's highly unlikely we get an opening statements today. Prospective jurors are back. One brought a giant box of Dunkin' Donuts. Ugh. That is one brand I don't enjoy. It's too heavy. Ugh. Ha, 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 ha. So did I, but do you know what? Sometimes, I mean, it was 12:45, then 1. I mean, it's just the judge, Michelle, the judges, someone saying they thought they were starting back at 1:45. The judge may be having something he's dealing with. Squeegee of Justice. Hey, still waiting for the feed. Let's see if Miss Notorious has done any updates. Okay, 17 minutes ago, everybody was waiting on the judge. We love them. Oh, they have a bowl of cheese balls. Oh, I love that icon. You guys, you get to create your own icons when you get to a certain point in your YouTube channel or your emojis. Excuse me. your own emojis. And I love my emojis. Just saying. I had so much fun with Miss Kevin making those emojis. It was awesome. 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 Why aren't you showing me now? I'm live. Am I not live still? Why aren't you showing me live now? There it is. Who is that coming in here? Oh, my beloved. Greg? I got to get this thrown up real quick. I accidentally deleted it. Y'all, Tracy is here, y'all.
Hi.
Uh,
Let me go sit down.
yeah, I'm coming. I'm going to say hi to her real quick, y'all, and I'll be right back. Okay? See y'all in a minute. Okay, guys, and here we go. I know I was a few minutes late. Apologize. My sister stopped in to pick up something. And here we go. Let me zoom. What are y'all saying? Oh, I can do that, Toy. I'm going to actually, I should do that because we're going to be adding more. We've got a couple new slots. Oh, Tracy, everybody says hello. She says hi. Toy, rephrase it. I just don't want to sit and look at that mugshot.
Do you recognize our panel?
Yes, Your Honor.
All right, thank you all. You all can be seated.
Here we go, y'all. Jury voir dire.
Members of the jury, thank you again for your time. Welcome again to 23 Alpha of the Orange County Courthouse. My name is Judge Michael Kranick, and again, I will be the presiding judge in the case of the state of Florida versus Sarah Boone. I am going to ask the state to introduce themselves again to you this afternoon.
Good afternoon. Dave Cacciatore, Assistant State Attorney. William J., Assistant State Attorney.
And defense, if you could introduce yourself and your client, please.
I'm James Owens, and I represent Sarah Boone.
Boom.
Tony Henderson, representing Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Shelby Andrews, jury selection and trial consultant.
Lauren Henderson, assisting the defense.
Thank you all. You can be seated. Now, members of the jury, yesterday evening around 5:15, I gave you an instruction. If you could please raise your paddles to show that you complied with the court's instructions in this case. Record will reflect all paddles have been raised. Now, members of the jury, I want to take a moment again to thank you. Yes, sir. Juror number 26. Juror number 39. Did you follow the court's instructions?
26 tattled on 39.
By you were able to hear the news yesterday, what does that mean?
I'm sorry.
Can we get her a microphone, please, for Madam Court Reporter? Thank you. Juror number 8.
Uh-oh, juror 38 almost got.
Yes, ma'am.
I was at my parents' house yesterday evening and they keep the news on and I was in the other room and I overheard it.
Okay. Did you overhear anything pertaining to this case?
Yes, I did.
Okay. Can the parties approach for a moment? Actually, just hold that thought. Ma'am, just hang on for me. We may have some follow-up with you individually. First, I want to take a moment and say thank you for your patience. I know I said we would start at 10 a.m. this morning, but one of those unscheduled breaks came up between counsel and I that you could not participate in. It took us some time to work through that, so I thank you again for your patience as we resolve those issues this morning. I want to confirm with all of you before I turn over questioning to the defense. As each and every one of you sit here today, are you an Orange County resident? Raise your paddles if that does not apply to you.
Oh, that would be horrible if you'd be going through this
Juror
and you
number
weren't a
45.
resident.
Yes, sir.
Are you kidding? Are you kidding?
When did you move to Seminole County?
That.
Okay, but are you still a registered voter here in Orange County? Okay, can the parties approach for a moment?
Oh, y'all. That's bad. That's real bad, y'all. I'll be right back.
I know, Sensei. I cleaned your ear.
Oh, let me get that thing for you. Okay, this was half off. Okay. And put a light up in there, those little pinch lights and the cords. Okay.
Oh, that's all you guys.
Huh?
That steakhouse they've been remodeling for who knows how long, they now have ads hiring staff.
Oh, yeah, I saw
So
that.
soon.
Yeah.
Oh, is that the one by?
HEB.
Yeah.
So I hope you like it. If you can't use it, tell me.
I haven't figured it out yet, but it'll definitely go figure out something with Christmas.
I can't stand
Maybe you can get a small candle.
We went there like once.
That's too small.
Thank you.
Cool. Okay, go home and go to bed.
That's what we ended up doing too.
I don't know if I
cooking
will.
here.
I need to go get some boxes. Oh, you have. No, I have to do it. Where were those? I have possibly those like this? Yep. I just need, yep, tan leaves are the ones that I need most. Yes.
What do you need?
My tan leaves back.
That's why I left those here. There you go.
These are mine. All of these are mine, but now these are hers. But I'm gonna keep these, because these now in my house.
That's why I left them there. I'm getting ready to decorate up front.
Shoot.
Come on, Susie. She's looking at me like, she's like, are you gonna make it? Come
I
on.
know, right?
I gotta get back on.
Yep, go get back on everything.
Love you.
Love
See
you.
y'all.
Bye, guys. Thank you
Bye.
guys for coming in.
Sure. Well, we were driving in.
Do we not have sound? Oh, I know. I didn't mute it. It's okay. We have nothing to hide. I apologize. Just trying to help my sis. Are they still arguing? We'll just zoom it up. Okay. I know. Well, our doorbell broke. Craig? No. Thank you for joining us. It's not normally this chaotic. For those of you who don't know, my sister is terminally ill. And she came in to pick up some things from us. And so I had to attend to my beloved. This long silence with her kills me. You're right, Wendy. You're right. This case is a cluster. Where is it? Definitely is a cluster. Thank you so much, Wendy.
Members of the jury, again, thank
Bye-bye,
you for
Craig.
your
We'll talk later.
patience. We're going to take a short break at this time. Don't go far, 5 minutes, just outside. And if jurors in seats 39 and 45 could stay behind. The rest of you, same instruction I've given you the last couple of days. There's still no case. Do not discuss this case. Don't do any independent research or investigation. And don't talk to yourselves about the case. You talk about anything else other than those things.
What's going on, Top Mark Media? Oh, thank you. Okay, this is going to be interesting. Yeah, I know, right? That should have been done when they mailed
Thank
out.
you. Y'all can be seated.
This is ridiculous. Absolutely ridiculous. Really? Seriously?
You're good. Thank you, sir. Appreciate you. All right. Jurors in seats 39 and 45, thank you so much. In speaking with counsel for both state and defense, we're going to go
You're
ahead and
dismissed.
discharge you from your jury service at this time. Please report back to the first floor, jury services. They'll validate your parking and give you any additional instructions. And again, I thank you for your time and your sacrifice during this week. Enjoy the rest of your week. And thank you again.
They're like, we're out of here.
As addressed at sidebar, jurors in seat 45 wearing badge 240 has been stricken for cause by way of stipulation, and juror in seat 39 wearing badge 551 have been stricken for cause by stipulation. One other additional matter, juror in seat 51 had advised either yesterday that did you recognize anyone? She had advised that there was a law student that she recognized she had seen at some volunteer organization. She's in fact Judge Leach's intern sitting in the box. And ma'am, if you please could introduce yourself for the record. Okay. So she is not a member of our panel. So I just wanted to put that on the record as to who it is that she may have noticed, and that person is not a member of our panel. All right, we'll be in a short recess until our panel comes up.
At some point, you were going to talk to Ms. Boone about the lawyers, some being out at the time.
Yes, okay, Ms. Boone, one of the matters that we addressed at sidebar out of everyone hearing is that I've noticed that one of your lawyers has been in and out of the room and sometimes been waiting, or this morning I asked you if you were prepared without your attorney being present. You said yes. Your lawyers have advised me that due to scheduling and speaking with other witnesses as to coordination, not all of your lawyers may be here all at the same time. It may be Mr. Owens, maybe Mr. Henderson.
Ooh, she ain't gonna like that.
Or less than that much. So the question I have for you, ma'am, are you?
I'm going to be off mic. I
on
got to
board
fix
with
it.
Proceeding without your full defense
coming
team
apart.
being present at all times?
I am.
Okay. Any further inquiry state as to that issue?
No, Your Honor.
Any further inquiries to that issue, Mr. Owens?
No, sir.
Okay, thank you all very much. We'll give the juror another 2-3 minutes and then we can have the deputy bring them back in. Thank you.
Okay, y'all. I am going to have to dismantle my mic. Yep. So please.
Try again, sir.
Can you hear me?
Patient.
That works?
I will
Okay.
be right back.
Good, okay.
Unsolicited advice?
Yes.
The tie, I think, works better because when it's on your lapel, it's very directional when you turn your head. That's all.
Oh, really?
It's that close, you. You can hear me pretty. I'll do it like HGN and move my whole body. So, keep my head still. Oh, fuck no. This is the third one.
My mic is laying down, so please be patient with me. I had something come loose on it, and I'm having to try to resolve it. Luckily, I'm a handy woman. Oh, luckily, I'm a handy woman. I try to be a handy woman. I think that would be better in that position there. I'm going to turn the mic off so you don't hear me banging around. Now I kind of know how RA felt when he had to fix his mic live. It happens, y'all. It happens. And I think I've got it in a better placement for me in doing so. Okay. I think that's going to work. My mic was straight up and down. Now, well, let me show you. I can put this off screen. Put me big. Okay. My mic used to be straight up and down like this, and it was hard to get it at a angle that benefited me. I'll be right back, y'all.
So 3, State of Florida versus Sarah Boone. State.
Steve Ketchum on behalf of the state. William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
All right, Ms. Boone still seated at council's table. We're bringing our jury back in. Let's all stand and we'll turn over the questioning to you, Mr. Henderson.
Testing. I'm back. Anyway, the microphone is more this angle versus directly up and down, which helps me a whole heck of a lot. Oh, yay. Oh, I like it. Already like it
Please
better
recognize our panel.
because it was getting involved
Defense,
with my
recognize our
typing.
panel.
Yes, Your Honor.
All right, members of the jury, again, if you could please, you can be seated, thank you. Can you just raise your paddles to confirm that you complied with the court's instructions during this last break? Record reflect all paddles
It does.
have been raised.
Makes it look
With
like
that,
she has almost
Mr.
like a
Henderson, you
black
may
eye.
proceed, sir.
May it please the court, counsel.
Oh, I like that better.
Ladies and gentlemen, good afternoon.
Good afternoon.
That was my first challenge in public speaking. I've been practicing all day that it's good afternoon because we're here in the afternoon. I'm used to saying good morning. So even I have challenges when it comes to public speaking. I want to thank you for being here. Again, my name's Tony Henderson, and it's my pleasure to represent Sarah Boone.
Oh, really?
And I know the judge has told you, but on behalf of our defense team, in regards to Ms. Boone, we would like to thank you. And I'm going to tell you why. America is still great. And the reason that America is great is because of systems like this that we have. It's our Constitution. Because in this country, our citizens are protected. In this country, we have limited government. In this country, based on our Constitution and the Sixth Amendment right that we have in our Constitution is the right to a jury trial. Folks, in some countries, they don't have that. In some countries, you don't have a jury. In some countries, they have professional jurors. In some countries, only a judge decides. In some places, you have to prove yourself innocent. We don't have to do that here. This is the way I rank these things. And of course, I have my bias as far as what you can do, the service that you can do for your country. I have this ranking. And I have a bias when it comes to this ranking, and I'll tell you about it. But number one, I think by far, is military service to your country. Number two, I believe, is jury duty. And my bias for the military service is the fact that my dad spent 22 years in the Navy.
Congratulations. My dad did too.
Overruled for now.
Coast Guard.
Number two is jury duty. Quite frankly, it's probably something I'll never be able to do because of the position that I'm in, but I would love to do it. Truly, folks.
True caring.
It's you that make this system work. All right. And number three, I think everybody should vote. Okay. Now I want to talk to you about the trial process, and this is voir dire. And voir dire means to speak the truth. This is my only opportunity that I will have to talk to you. Okay? Because once these proceedings start, it is against the rules of conduct for us to have any communication with you on either side, being on the state side, being on the defense side. So if you were to run into us or see us somewhere and we don't look at you or we don't acknowledge you, we're not being rude. Okay? We're just following the rule. And it gets ingrained in us because this afternoon, when I came up the elevator, it was a couple of people with jury badges on. I made sure I didn't say anything. Okay? But that's the reason. But for a trial, I break it down to it being 4 fundamental rights. And these 4 fundamental rights apply to everyone. They would apply to me if I was on trial. They would apply to you if you were on trial. They would apply if you had a loved one or a friend on trial. Today and for the rest of this trial, they apply to Miss Sarah Boone. And the first one of these fundamental rights you've already heard about, but sometimes people say things differently. And the first one is the presumption of innocence. We've all heard that term, correct? Raise your paddles if you've heard that term. You probably heard it enough yesterday. But prior to yesterday, I'm sure you've heard that term before. Is that correct? Could you raise your paddles if that's correct? And all of you have said that you can presume Ms. Boone to be innocent. Okay? That means at some point in time, and the judge is going to read you an instruction, and I believe the judge already did yesterday, that presumption of innocence means that you believe that she is innocent.
What? No. Oh, come on, Tom. Oh, come on. I'm getting it, y'all.
Oh, wrong one.
Okay. Any,
Oh.
not how motions in limine work.
Correct.
I don't know what else to take.
I'm working on it. Some of the other teams are not carrying this afternoon session. This is so weird. They carried this mornings. They have the upcoming, but they don't have the current. Is that why? Okay, we got the feedback. Did we? No. I know. It's not their fault. It looks like everybody's down. This is not anything to do with them. I'm going to have to turn to this screen and this monitor. Oh, I'm really liking the mic this way. Why did I take so long to do it? Okay, let's try. No, that's not what I want to try. Let me put this back over here so if it pops up, we have it. Got it. No, I don't got it.
Thank you very much. The second one of these I want to talk about.
This is not me. This is them.
About proof, okay? You heard about that yesterday. The judge told you in any criminal case, it's certain of proof. It does not have to prove anything. Okay. Well, jury number 6. Sir, do you know why the state has the burden of proof? Why should it be? Do you think it should be that way? That the state?
If they're prosecuting her, yeah.
Why?
That's the law.
Okay. Can anyone else give me a different reason by show of paddles that?
I can't find anybody else covering it live. Ronnie, if you find anything, let me know. Although I think the same feed's going to be for everybody. Well, they got 15,000 people watching Sarah Boone pretrial motions with another streamer, but this is the only feed that has a live feed into trial right now. Everything else is old. They're tracing the bugs. Okay. We are patient. We are kind. We are patient. No, she has no remorse. None. I'm sure Scott's going crazy over there. Is he even live right now? He too is having the same problem. It's his feed. Zimmy's like, I checked all the cables back. There we go. We got that up. I'm watching their feed. Poor people. I know. It's hard. They've got a lot. Yeah, they're the only stream. I hear him speaking. Are y'all here, Mr. R.A.? Or is it just me? Am I on his? Yeah, I'm on his. I've got his channel, but I didn't know if y'all can hear it. Okay. We have a moment for a break. Uh-oh. Oh, that doesn't work. Oh, dag nabbit, I gotta fix my mic. Yep, it's coming apart again. Everybody's having their issues today. Oh. RA is having his heater worked on. Poor guy. Every time you turn around, he's got something he's got to get worked on the house. Oh, don't you go flying. I won't find you. Don't go flying, please. Don't go flying. There we go. He's established. Dropping out again. Why don't we have the feed? RA. Hello? Yes, RA.
As to element B, there was,
They're working on it.
but as to element C, you have a reasonable doubt.
Mm-hmm. I'm working on my thing, guys. Give me a minute. I'm going to mute.
Okay, and I used to try to say, Granny, it don't work like that. But that was her fundamental belief. Okay? Is there anybody who feels fundamentally like my grandmother? Anyone? And it's something that I forgot to tell you when I went into this for die and talking about it's to speak the truth. And why this is so important at this point in time, folks, because guess what? I can't read what's in your mind. Okay? I can't. But more importantly to me, I don't know what's in your heart. I don't. So you have to tell me. And if it's something I say that confuses you or you don't understand, raise that paddle and I'll try to clarify it. Okay? All right. So, do you know what that means? Because the judge is going to give you an instruction about if Ms. Boone elects not to take the stand. And that instruction is going to include that you cannot consider that in any way in your deliberations. Do we understand that? Okay, great. So guess what, folks? You're back there and you're talking and it's close. And someone says, well, we didn't hear from Ms. Boone. Nope, that's wrong. Do you understand? Because you cannot consider it in any way. Do we understand that? Yes. Okay. Can we all adhere to that? Okay. Anyone who with a problem with that? Okay. Thank you. So none of my grandmothers out there. All right. All right. I'm going to get to some more case-related questions, as I call them. I just want to make sure, is there anyone here who knows someone with the state attorney's office?
Testing.
Anyway.
Yep.
Anyone here who knows someone from the state attorney's office? Anybody who works at the state attorney's office?
Aww.
Show of paddles if you do. No one? All right, good, thank you. All right, there was a question asked yesterday about interactions with law enforcement or who knew people or related to or had friends with law enforcement. I remembered we took them down. I want a follow-up to that question that I just want to ask you, okay? Is it anyone who has such a close relationship with law enforcement that it would be hard for them if they're on this jury and after they listened to the evidence
Right.
and said to
Yeah.
themselves, the state did not prove this case.
True.
And we had to find her not guilty because we followed the law. Is it anyone in a relationship would have a problem telling that person that's what we had to do and that's what we did? Anyone in that type of relationship? Okay. Thank you. Now, in the state of Florida, there are certain things that we have that are known as affirmative defenses. Okay? One of these things that we know as an affirmative defense is the justified use of non-deadly force and also the justified use of deadly force. Okay? AKA, meaning also known as self-defense. All right? I think everyone's nodding now because they recognize that term, self-defense. By the show of panels, how many people recognize the term self-defense? Is it anyone here who disagrees with the principle that a person has the right to defend themselves? Show of panels. Anyone? Okay. Is it anyone who disagrees with the thought that a person has the right to defend others? Anyone fundamentally disagree with that? Basically, what I'm asking is anyone who thinks that slap my cheek, and let me turn the other one to you so you can slap it.
Oh, you're going biblical now.
Anyone?
Really? Don't throw the Bible in here.
Has it been anyone in this panel who's ever been put in a situation where they had to defend themselves? Just show of paddles, please. Yes. 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 Anywhere. Those are all good questions. Anywhere that you've been in the position, it could have been at school and someone's come up and started picking on you or hitting you or whatever.
Everyone.
Do you understand? Okay.
Everyone.
Yes, we're talking about physically defending yourself. School, middle school, it could have happened. It could have happened when you were in diapers. Okay.
Oh my gosh.
Yeah.
Really?
So at any time in your life, have you felt or did you have to defend yourself? Can we show paddles, please? Okay. Could you hold him up? And we'll start because my arm would get tired. It was getting tired yesterday. You can, this is my left side, so on the right side, correct? Okay. Yes, just on this paddle. And that's paddle number 1, paddle number 2, paddle number 4, paddle number 5, paddle number 6, paddle number 7, paddle number 15, paddle number 17, 18, paddle 32, paddle 41, paddle 43, paddle 44. Then we're going to be in paddle 47. I'm sorry, sir. Were you holding it down? I just missed you. Okay. Thank you. Now, this side. Paddle number 14. Paddle number 24. Paddle number 26, 27. Paddle number 36, 38, 48, 49, 50, 51, 53. Okay. Would you all agree with me that each of those situations would have been different? Anyone who disagrees with that?
Lord have mercy.
Okay.
Give me strength.
So would you agree with me that each of those different situations, if you disagree, just raise your paddle, that each of one of those situations would have to be determined on their own merit and their own facts? Would you agree with that? Okay. Is there anyone who disagrees
We're in the voir
with this?
dire.
A person has the right to defend themselves, even if it means using a weapon.
Objection. Who's stating the law?
Depends.
Approach.
Guys, this is absolutely freaking driving me nuts. It is. For multiple reasons. Oh, sorry, y'all should have told me to get rid of my dang banner. Y'all, I'm going to go ahead and biggen me. Kind of put me in a little better window. Sorry. This is driving me crazy.
Mr. Henderson, you may continue.
This line of questioning is stupid. Royally stupid. We've all
as
had
I
to
told
defend
you
ourselves.
before, there's two types of self-defense, okay? Self-defense with non-deadly force, all right, we're not going to be talking about that in this line of questions, all right? And the line of questions that I'm talking about is that self-defense with what's known as deadly force, okay? That's basically force that is likely to cause death or great bodily harm.
Yes.
All right, do you understand me there? Okay?
Yes.
In that situation, you have to be in fear of that time. The person has to be in fear of that time that is going to be an action against them or a threat or an imminent threat against them of being harmed with great bodily harm or death. Or a forcible felony is being attempted on them. Do we understand that? Examples of forcible felonies are aggravated assault, aggravated battery, felony battery. Some examples, okay? In that type of situation, is it anyone who believes that a person should not be able to use a weapon in defending themselves?
I'll have to tell you some of my stories.
Is it confusing?
I have a few. I have a few. I have drawn my weapon.
Can we get
Yeah.
a paddle number?
Yes, please, I will. Paddle number 24.
It depends on the situation. I mean, they can negotiate and.
What did he say BS? Did he use the BS word?
Okay. Now let me ask you a couple other questions, sir, during number 24. Yes. Thank you. During number 24, when the court reads you the law on justifiable use of deadly force, will you be able to follow that instruction?
Yes.
Okay. Now, would you agree with me that every situation is different?
Yes.
Is that correct? Okay. Let me give you an example. If someone was to put a gun in your face,
Right.
okay, do you think that you have to wait for them to fire it?
No.
Before you fired your gun?
No. Self-defense first.
Is there anyone who thinks that you should have to wait? Anybody? Okay. So in certain situations, based on the facts, are you saying there would be times when you feel it would be appropriate to have to use a weapon?
Yes.
Well, I don't want to put words in your mouth. You tell me.
Well, if your life is in danger, you do what you can. It depends on the moment that you're in, but even though you try to look for peaceable solutions,
There you
but
go.
if your life is in, if your back is up against a wall, there's a knife at your throat, you do what you can. Not the intent to kill, but to resolve the situation without being killed, if you understand that part. Yeah.
Okay.
Guys,
Would you judge it by each situation, sir?
some people have registered deadly weapons
Yes,
that are
every
their
situation is
fingers and
different.
hands.
Let me ask you this.
Just saying.
Would you consider
I know, right, Karen?
physical ability when it comes to it?
Can be physical, and it can also be negotiating verbally. Sometimes
Yes, he does.
that works. Depends on what the attacker's motive is at that time. So, you know.
It depends on, are you in fear of your life?
Let me give you
Period.
this example, and then
Not
you
his
tell
own
me about
life
that.
and limb.
What if it's a male, 6'5", 200 and something pounds, and a female, 5'2", 105?
Objection? Approach.
I know, right, Karen? Basically, if I understand the law, I'm not a lawyer, but I'm on the path. From what I remember and took in my training, if you have fear of life and limb, that's all. You don't need to sit here and rationale what the intent is. If the guy is coming at you with a weapon or a woman and you fear for your life and limb and you cannot get out of the situation, you can do it. One of the things that get me though is a lot of people don't try to leave. Some people feel like, oh, I'm fearful. Bang. Yeah, this body weight thing bothers me. But the first thing is try to get out of the situation. Avoid the pulling of the lead shooter. However, if you are in a situation where you must defend yourself by taking life and limb,
Sustained. Mr. Henderson, you may continue.
Yes.
you just have to be in fear of your life.
Sir, I need to change that. Male, 6'5", 200 and something pounds. Okay. Female, 5'9", 120 pounds. Okay. Would you consider that when it comes time to how a person would have to defend themselves?
Yes.
Come here.
If it's life and death, it's either their life or your life. So yes, it would be, if that's the last resort and there's no other recourse, I would say yes in that situation, because it's either their life or your life.
Okay. All right. Let me ask you this, though, and looking at like when you say it like that, but would you be able to recognize the difference in probably the physical abilities of a man who's 6'5" and 200 and something pounds versus a woman who's 5'9" and 120 pounds?
I know, isn't she?
Well, are you talking about the lady defending herself against the guy that's?
Yes, sir.
Well, in that case, is the survival. You know, I mean, she can either run away or depends on.
If you can run away, then you are no
But,
longer
I mean, my
in a
point
position.
is, you try to avoid deadly force if at all necessary. I mean, that's the last
Hypothetical,
resort.
Adair.
You can. You don't use it, but if that means your life, then of course, in that case.
I do like those.
Thank you, sir.
Yes.
Juror
Guys,
number
if you
5.
can run away and you choose not to, that's
What's your
questionable.
opinion on that?
As a woman, I would want to defend myself, and no matter how big of a guy, I'm going to try to defend myself until either hurts me or
They're going to be disappointed when it finds out it's not a weapon, but a suitcase. I wonder what they're going to think when they find out this
We
is
have
not a
juror number
weapon.
10 here.
It's a suitcase.
No. You got me. I should have had my seat chart. 10. Juror number
I'm missing it already.
17.
Get on the mic. Get on the freaking mic. Please get on the mic.
Can we get the mic over there, please?
Thank you, Your Honor. Did
Sir,
you hear
yes,
that?
could you repeat?
Listen. Who said that? GD.
Sir, yes, could you repeat that, please? Juror
I'm
number
going to get a hold
17.
of the honor and tell them the lawyers need to not be saying the GD word. The mic's picked it up. Exactly, Ronnie.
Thank you. Does that work?
They're getting this
Yes.
jury a
What I was
picture
saying
of
is if
what's
there's
going to
a
happen. They're going to be
larger,
gravely
more
disappointed.
imposing physical presence there that you're fighting against, that could put you in a situation where you have no choice but to use whatever's available to you, because in the example you gave,
He said the GD word under his breath. GD. I rewound it to verify it. I was like, what you doing that for? That's not professional. I kind of want to email the county clerk, the clerk of court, and let her know the mics are picking up the judge, I don't know if it was a judge. I don't know if it was a lawyer, but the GD word was definitely picked up.
you're not going to win that fight.
Remember, you have a hot
99
mic.
100 times.
Thank you, sir.
Sounded like
Is there
his voice.
anyone who disagrees with what juror number 17 just said? Hold your panel up if you disagree. Is there
Okay.
anyone here who, are you holding it up that you disagree, sir? Okay, thank you. Anyone else who disagrees? All right. How many people show a paddles who agree? To what he said. Who agrees? Okay. Thank you.
Y'all go to Instagram or X and look up Notorious Jewels or Blind-Faith 1423. And subscribe and like and follow or whatever you do. Support her because she's
You all
helping
understand,
us.
in the state of Florida, when it comes to defending yourself, either with non-deadly force or deadly force,
No,
that you
ma'am.
don't have to wait for the commission of the act. Do we understand that? Am I confusing anyone?
It's
Okay.
what's perceived as a deadly threat.
Meaning that if someone holds their hand up and fist up and make like they're going to hit you, do you understand that to use non-deadly force in that scenario, you don't have to wait for them to hit you? Do we understand that?
It's perceived threat.
Okay. Also, in the use of deadly force, if someone holds up a gun All right? You don't have to wait for them to fire it. Do we understand that? Yes. Is there anyone who disagrees with that? Also, in the state of Florida, if it's two people or someone has knowledge of a person or the other person who's exerting force on them, if they have had difficulties or events in the past, that could be considered in their use of either non-deadly force or deadly force. Do we understand that? All right, if you understand that, show of paddles, please.
Good point, Haley Mouse. How about when someone's begging for their life, desperate, sticking two fingers out to escape? Is that deadly force?
Let me try to give you an example. A and B are school kids, okay? They
No,
go to
please
school
don't.
every day. Let's go. Let's say they're in middle school, all right? And for the past couple of weeks, you know, A has been beating on B, okay? So A and B go to school again one day. Next thing you know, A comes up to B. And B just automatically hits A.
He's, to me, not giving very good, he's not giving very good examples. Neither one did, really. I thought the baseball, if you're a baseball player, I guess you get it, but y'all,
Objection is
a test.
sustained. Mr. Henderson, you may proceed.
Never mind.
Let me try to explain it to you like this, ma'am. If you hear an instruction that you can consider past difficulties between the parties if in determining if someone was justified in using non-deadly force and deadly force or deadly force, could you follow that instruction? Okay. Is there anyone here who could not follow that instruction? Yes, ma'am.
I need a microphone.
Oh, okay.
We get juror number 13, the mic.
I'm not doing a good job with the mic. I'm sorry.
Yeah,
So
you
like in
know
your
you're not.
example, if I'm allowed to use the example that you were just using on A&B, no.
Not the example that I used before. Okay. That was found to be wrong.
Okay, so I guess my question is, even though there's been past events that have happened and they could weigh in with that, something still has to be happening in that moment for them to
ding, 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 ding,
defend
ding, ding,
themselves
ding,
in
ding,
that
ding,
way, right? It's not like
You're absolutely,
somebody walks up to you and you can just defend yourself.
you're
because
absolutely correct. Because what the statute is going to say and what the instruction is going to say, that has to be an imminent threat. Okay. An imminent doesn't mean that you have to wait for it to happen.
Where was the imminent threat with him zipped up in the suitcase begging for his life? Please, you just lost your case. If am I the only one? Am I the only one? Please tell me. Am I? Yeah, they're going to strike her big time because she knows. Oh my gosh, y'all. The attorney just agreed with her, but that's not the defense he's putting on. And guess what? These people, if I'm in their shoes, I'm sitting here thinking he had a big man, little woman, somebody had a fight, somebody shot somebody, or she shot somebody, and it's self-defense. Boy, they're going to be greatly disappointed when they find out that the victim is 103 pounds and 5'2", 5'5", and was zipped up in a suitcase in positional suffocation. They're going to be disappointed.
But you have to have reasons to believe that it's going to happen. Okay. But the instruction that I'm talking about, do you understand that past difficulties can be considered? Because that's what the jury instruction says. Can we
But
follow
Haley
that
Mouse,
instruction?
she could have left him
Is that
and
correct? Can
called
you
the
follow that
police.
instruction, ma'am? Okay, thank you very much.
No, she could have left him and called the police. She could have zipped him up, tricked him in there, zipped him up, yell at him for a little bit, get out of the house and call someone and says, I left him in there. I need y'all to come let him out. And I'm in fear of my life. So I didn't let him out and I need the police to go get him. There was no imminent threat. I don't think he would have harmed her in the way that she's trying to lead us to believe. And if he did, then she had every, and once again, I know with my training, may not be the law, but way I was taught, if there's a way out without using deadly force, and you do not attempt to take that out, and you jump to deadly force before using any other method when it's not necessary, that's murder. Exactly. Haley Mouse, you're right. I'm talking about her. I'm saying she got him in the suitcase and she was terrified that he was going to be so pissed when he got out. She just wanted to punish him. And so how was she going to get out of that without him hurting her? You leave him in there. You leave the house. You call someone and let them know he's there and get someone to let him out. You leave. She slept there. Yeah. Under the law, that's no excuse. I'm playing devil's advocate too.
How many people here own guns?
No.
Or
Oh,
at
I'd be in
least
trouble.
one gun.
I'd be in trouble.
Okay. All right.
And if they
Let's
asked me how
start
many, I said, I
on
don't
this
feel
side
comfortable
over
answering
here.
that on live TV.
Juror number 4.
I'll talk to you
I'm not
privately.
going to ask you how many you own.
Oh,
That's
good.
your constitutional right. I'm not going to. I asked that one time. Somebody said, "I'm not telling you how many I own." So I
That's
learned
right.
from that. What do
I
you?
would-
What's the purpose of your gun?
My American right.
Yes.
Self-defense, and then they're just on the street.
Okay.
Recreation.
All right. Thank you. Juror number 5.
So they're actually my husband's.
Bye.
They had purchased one for me for that reason. If he was home or not home with, and I was by myself with my child, someone were to break in, we would have.
I have many reasons.
Okay.
That would be my
Thank
answer.
you. Who else on the first row on this side owns a gun? Anybody else? Second row? Yes, sir. Juror number 15.
She
Excuse
did.
me?
I
You
dare.
have to speak up, juror number 15. Oh, there we go.
It's basically for home defense. That's all.
Home defense? Okay, thank you. Anyone else on the second row on this side? Juror number 17.
Exactly what she said. Exercising my right, self-defense, and I like to target shoot.
Okay, thank you. Anyone else on this row? Yes, sir. Juror number 19.
None of your business.
Self-defense.
Self-defense.
Don't really shoot, but I have it in case I need it.
Okay, thank you. Anyone else on this row? Third row on this side. Anyone owns a gun? Okay. Last row on this side.
I don't know.
Anyone?
It's kind of
Let's
hard.
start with juror number 44 because she has the mic.
I really struggle telling them that I love, that I have a weapon. I would say that I have in the past, but whether I do or do not now, I am not going to disclose for my security and safety. I may or may not. And why I did? Because I can. I hate it when people, and if this was not on camera, that would be a little different. But this being on a national camera, hell no.
Mike, I
Kick me
believe.
off the jury.
Same reason as the lady up front.
Okay, thank you. Juror number, what's your
None of
panel number, ma'am? 43, thank you.
For self-protection, I live alone and also,
A dare.
my job, I have drugs. And so somebody could, I'm a veterinarian. So
Okay.
if anyone knew that and people are,
Why are you saying that?
then they might want to break into
You're
my house
just
and try to get
advertised
into my
it.
truck.
That's the point. She just advertised it. I would say work related, period. If they say what, I'd say I'd rather not disclose that publicly. End of discussion. People, you talk too damn much. Don't talk so much. Just, yes, work related, period. Anything else, private.
And get drugs.
Or in other words, if anyone gets froggy.
I'll be back.
I'm sorry?
I said froggy, it's a slang term, I'm sorry.
Yeah, so just, I mean, it makes me feel safe.
Okay, thank you. And sir?
Yeah, just old hunting shotguns.
Okay.
Hunting rifle from my father and grandfather.
All right, thank you. Anyone else on this side, on a gun? This side, if we can have the mic come this way, would be great. Do they have a mic on this side too? That's great. It's like a relay team. All right. Juror number 23.
For self-defense.
Self-defense. I like your juror number, sir. That was my football number.
Home defense, and recreation.
And recreation. Thank you, sir. That was juror number 24. This is juror number 26.
Home and self-defense and shooting practice.
Okay, thank you. Anyone else? Oh, did I get the first row here? I didn't get the first. Yeah, juror number 8. Sport and recreation. Okay, were you able to hear that? Okay. All right. Now I'm on the third. Anyone else on the second row on this side? On the third row on this side, anyone gun owner? Juror number 37.
Just for recreation and home defense.
Okay. Anyone else on this side? On this row, I'm sorry. Back to juror number 51. Thank you, ma'am.
I don't own a gun, but my husband bought one for target shooting. I don't even know where it is, so he's got it locked up somewhere.
Okay.
But it's not for home defense, though.
Okay. Well, thank you, ma'am.
Is that it?
Recreation, home defense, and our rights.
Your number, please, your panel number. 49. Okay. Thank you, sir. Anybody else? Anyone I miss as to gun ownership? All right. Thank you. Folks, if you disagree with this,
I'm really struggling with
raise
them
your
asking
panel
that
for me.
question. That I'm struggling with.
Yeah, I'm sorry, I'm about to say. If you disagree with this, raise your panel, okay? Your home is a sacred place. Yes, anyone disagree with it?
I get it. I understand, Lady Mouse. I
Your
just don't like
sacred
it.
place. Your home is a sacred place, okay?
No, you cannot, Toy.
All right, let's do it this way. I'm sorry, yeah. I did it the wrong way. Let's
You're
do it this
sworn
way.
under oath.
If you agree with this statement, raise your panel, please. Your home is a sacred place. Okay. Is there anyone here who believes that you can't defend yourself in your home? Okay. If you do, raise your panel. All right. Thank you. All right. It's going to be one other thing that I'm going to talk about with this justifiable use of non-deadly force or justifiable use of deadly force. Okay. And it ties in with the burden of proof because remember, it's the state, the government who has the burden of proof. All
Okay.
right? However, folks, once the judge reads you an instruction saying that it's an affirmative defense of justifiable use of deadly force or justifiable use of non-deadly force, do you understand that Ms. Boone does not have to prove to you that she was acting in justifiable use of non-deadly force or justifiable use of deadly force. Do you understand that? Guess what has to happen? Juror number 3. I hadn't picked on you. What has to happen,
She's
sir?
enjoying
you know what
this.
has to happen?
She's liking
What do they have
their
to prove?
answers. Beyond reasonable doubt.
Yeah, you're really close, but this one's tricky. You're really close. You're almost at that. But you know what? The state has to prove to you that she was not acting in self-defense. Either deadly force or non-deadly force. Do we understand that?
But this was not a
Okay, 'cause
freaking
it
gun.
gets
This
a
was a
little tricky when you
suitcase.
think about it. So she doesn't have to prove.
Jeez, I didn't mean to do that. This is not deadly force. This is a suitcase, for
The state
God's
has to prove to you that she was not acting
suitcase, not a gun.
in self-defense. Either deadly force or non-deadly force. Do we understand that? Okay, because it gets a little tricky when you think about it. So she doesn't have to prove that she was. That's the instruction that's given. She doesn't have to prove that she was. They have to prove that she wasn't. Do we understand that?
That is a fair point. Good point.
Can we
He
all
scored
follow
one.
that? Is there anyone who thinks it should be a different way?
No, Haley Mouse, she does not. They have to prove it. She doesn't have to prove anything. But if you bring it up, you better have something to back it up. That's the way it's.
Anyone here,
she doesn't have to.
and I think a little bit of this man came up yesterday,
They do.
that has ever been in a situation that either they were abused or part of an abusive relationship,
Not again.
or they know someone who was abused and part of an abusive relationship?
That should be
Show of
everybody.
panels, please. Okay. And if I remember correctly, didn't we cover this yesterday and these things? All right. So I just have a couple additional things that I want to talk about when it comes to this.
That's what I want to do. No. We're not going down the abuse again.
Is there
No.
anyone who disagrees with this? That sometimes people are just embarrassed and don't want to talk about those situations.
Oh, that's good, Zach.
If you disagree with that, raise your panel, please.
Well, that's true. Some people don't.
Do we understand that? Okay. Would you agree with this, that sometimes the person being abused tries to minimize the situation? Is there anyone who disagrees with that?
Nope. I do not. I think George may have. That's a good point.
Is there anyone here who either
Good point.
themselves, yourself, or know someone who has stayed in an abusive relationship over an amount of time? Raise your panel. Okay. Is it anyone here who has ever tried to talk someone into leaving an abusive relationship? Raise your panel. Okay. Thank you. All right, we're going to start over here. Juror number 2. Without telling me who it was or what the situation was, did they follow your advice?
Yes.
In the end? Did it take a while? About how long did it take?
number of years before I even met them. They ended up leaving after about a year and a half to
Okay. Anyone else on this front row who had to paddle up? All right. Second row on this side. Anyone? Yes, ma'am. Did the person listen to you? The microphone's right behind you, too. I'm sorry.
No, they did not.
How long did you try?
Well, over a year.
Okay. Thank you, ma'am. Anyone else on this row? This second row? On this side? 21, can we pass the mic down, please?
I too found out late in the game, but when I did, it did take a little while, a couple months.
Okay. Thank you. All right. Anyone on the third row? All right. Thank you.
She left the person after about 10 or 11 years, but it was not because of anything I said. And I did talk with her the entire relationship.
Okay. Thank you. Anyone else on this third row? Fourth row? Yes, ma'am. Juror number 43.
One girl, I tried to help her, so I let her stay with me, and I brought her here to do a restraining order, but then it all fell apart. And then she was a mess, so I got her out of my life, but I don't think that it would have made any difference.
Okay.
And then I also know quite a few clients, not very well, but you see it happen over and over, and people usually don't leave.
Thank you, ma'am. Is it anyone else on this row?
Interesting,
Okay,
Karen.
let's go to this side.
I do have some
Anyone
shimmery
on this
eyeshadow
side?
on.
Juror number 8. Where's our mic here? Here it comes. Yes, sir.
No, they did not leave the relationship.
Okay. How long did you try to talk to him?
Years.
Okay. Thank you.
This is
Anyone
true,
else on
Haley.
this row? Yes, ma'am. Juror number, please.
I
13.
think the actual thing they'd be
Same
doing is
years.
he's the
I think
victim.
in most cases that I've seen, like it
Amber Heard, Johnny
just
Depp.
has to be them that finally makes the decision. It doesn't really matter what you say.
Okay.
Oh, they're going to like her. They're going to like her a lot. That is going to be a juror they're going to fight for.
Anyone else on this front row? All right, second row. Anybody? Juror number 28.
It was about 2 years. They eventually left on their own accord, but I was there and support, offered a safe place, and they would go back. It has to be their decision.
Ma'am, thank you very much. Did y'all hear that? When they said it has to be their decision. Is there anyone who disagrees with that?
Okay, Jules has made some observations. Number one, Mr. J has made 5 objections so far during Mr. Henderson's voir dire. Sarah Boone looks at Mr. Henderson with adoration. This is her lawyer that she spends a lot of time with. Oh, do we have a Boone crush happening? Snap it. Didn't mean to do that. Meant to do play.
Okay. Thank you, ma'am. Anyone on the third row?
Interesting.
Anyone on the last row? Yes, ma'am. Yes, sir. Where's our mic?
Gosh, I love how he's so.
Hey.
3 years, they didn't listen. The guy ended up leaving her. She grabbed him and go back to him probably today.
Okay. Okay.
I want to say, yeah, me,
that was
10
hard for you
years,
to
I married the
understand,
dude. And I buried him. Oh, I'm kidding.
Okay, that's fair. That's correct. Well, simpler in some ways.
If this wasn't so serious, I'd mess with their brains so bad. I would throw them answers. They would be going, huh? I would.
Harder
It's
than
too
others.
serious.
Anyone else on this row? Yes. Juror 50.
My cousin is off and on in the relationship. The family knows. We've tried to talk to him. It's ongoing.
Okay. Anyone else? Yes, ma'am.
A colleague, and I talked to him for maybe a month, but they did it on their own years
Okay.
later.
Years later? Thank you.
She's right. She wrote N-O. I'm watching her pen. She went N-O.
Is there anyone here in the panel who's ever had an injunction filed against them for no contact, that you couldn't have contact with a person? Anyone here? Excuse me? Somebody else, but not, it wasn't against you. Is that right, ma'am? Okay, thank you very much. Yes, sir.
Mike.
Okay.
Mike Elaine.
All right, and that was your wife, correct? Not yourself. Okay, thank you, sir. Thank you for your candor. All right, anyone else? Thank you. And that was jury number, what's your pallet number, sir? 15 and ma'am, 13. I got it. This term came up yesterday, battered spouse syndrome. There were some people who said that they were familiar with the terminology, okay? So I know that, and we've taken, we have that information, okay? But this is something that I want to talk about. Did anyone here who knows someone, friend, relative, who just knows everything about anything, if that makes sense?
You mean a know-it-all?
Anybody
Do I
show
know
a
a
pen?
know-it-all?
Do you know someone
Yeah.
like that?
I see her every day.
Okay.
Looking right back at me.
All right, so there's very few people who know someone like that. Well, we all agree that there are just things in life that we don't know about.
Oh,
right? Anyone disagrees with that? Panel?
guys, I have to do it.
Okay. Guess what? When my car breaks down, I'm going to the mechanic because I don't know a thing about a car. Okay. Now, when my AC or air conditioner goes out in the summer, I'm calling the guy as quick as I can because I know nothing about the AC. Do you understand that? Okay. So
I understand you're an apt
when
at
the
running
car
a home
guy
then.
says, "Oh, Mr. Henderson, it's going to cost you about $2,000." You know, what do I want to do? Well, what does a reasonable person? Well, what's wrong with it?
Where the hell are you going?
But guess what? It gets to a point I have to rely on the car guy because I don't know about it. Do you follow me there? If I get sick or if anyone gets sick, where do you go? Do we have any doctors out here? Okay. Thank you, ma'am. And did you say that's the vet clinic? Do you? Yeah, I'm a veterinarian. You're a veterinarian? Yeah, I have a German Shepherd. The patients don't talk to you. Yeah. Yeah, I let him stay with some people who had dogs, and he don't even miss me. I've been here in Orlando all this time. But, so, what do you go to the doctor for? Yeah. Aren't you trying to find out what's wrong? Okay. Folks, there are some people under the law who become expert or known as expert witnesses. Guess what? Because they know about a topic more than we know about a topic. Do you agree with me there? Is it anyone who disagrees
I do too, Zach.
with me on that? Raise your
That's
paddle
worse
if
than
you
a human
disagree.
in a suitcase, y'all. Doggy in the suitcase. I wouldn't mind seeing a few humans in suitcase.
Can you all, by show of paddles, listen to an expert testimony and weigh it accordingly? Can you do that by show of paddles? Everybody can do that. Is that right? And guess what? You're not going to hear me say anything else about an expert because I really don't know about the expertise. That's why we have the expert. The expert can talk about it. Okay? We agree with that? Everyone agree? Okay, thank you. All right. There's been talk about fear and fears and what kind of fears people can have. Okay? If you disagree with this, just raise your paddle. Oh, no, let's do this. If you agree with this, raise your paddle. Okay? That some people can have.
What should go on
fear
the
of
bingo
not being
card? Tell
wanted.
me some words.
Do you agree with that? Okay. Thank you. Anyone disagree with that? Okay. Some people can have the fear. Oops, excuse me. Yes. Thank you. Number 6. I'm not even going to ask you to explain it because I understand some things we just don't agree with. Okay. All right. Thank you, sir. All right. Some people can have the fear of not being good enough. Would you agree with that? Okay. Is it anyone who disagrees with that?
Y'all drop some words for the bingo card. I'm
Thank
making
you.
one.
Paddle number 6. Thank you. All right. Some people can have the fear of being hurt emotionally or physically or both. I said that all backwards though, but you know what I mean? I should have said emotionally, physically, or both. Okay? Anyone disagree with that? Okay. Number 6? Good? Okay. Is there anyone in the panel by show of your paddles that's claustrophobic?
Oh my
Okay.
gosh, really?
Can we keep that up? We'll start on this side first. Juror number 3, thank you. Juror number 34, thank you. Juror number 44, thank you. 44, did you get it, Miss Andrews? Okay. Yep, you can put your paddle down there. Juror number, this side, paddles up, please. Juror number 9, all right. Juror number 40, juror number 51, juror number 53. Okay. All right.
We
you.
need it.
Is it
What is it that
anyone
we didn't think
here?
we were going to hear
Maybe
on
I
the
asked this
bingo
in
card?
everything, but let me make sure. Who has a medical background? I don't mean a doctor, but just has a medical background. Okay. Let's do this. Could you hold your? We're going to start on this side over here. Could you hold your paddles up high, please? All right. So we're going to go juror number 5, juror number 16, juror number 18, juror number 21, juror number 31, juror number 43. Thank you. Anyone else on this side? All right. On the right side, juror number 51. Anyone else on this side? Thank you very much. All right. I have to talk about another topic here. Alcohol. It was brought up yesterday. Okay? So this is what I need to ask you. If anyone disagrees with this, just raise your paddle if you disagree. That alcohol affects people differently. Anyone who disagrees with that? Well, let's do it with agree. It makes it easier. I'm sorry, I get confused. I'm confusing people. Let's do it with bit. Anyone agree? Who agrees with this statement that alcohol affects people differently? Do you agree? All right. Anyone who disagrees with that statement? Okay. Now, would you agree with this? Who agrees with this? That sometimes people or certain people drink alcohol and they get happy and giddy. If you agree with that, raise your paddle. Okay. Sometimes people drink alcohol and just get downright mean. Do you agree with that? Raise your paddle. Okay. Anyone who disagrees with that? All right. Folks, sometimes there's people who don't drink a lick of alcohol and are just happy and giddy. Would you agree with that? Okay. Anyone who disagrees with that? Folks, sometimes there are people who don't have a drop of alcohol and they're just downright mean. Do you agree with that? All right. Thank you. Now,
I drink. I'm asleep. I wouldn't know a
I
freight
think
train
yesterday
coming
it was
through my
jury
room.
number 4. Jury number 4, correct?
Okay, guys. We're going
You
to take a
drank.
quick break. On my bingo card, we have suitcase, wine, unintentionally, shh, good day, game, puzzles, art, all in one row. I understand. She said that a lot. What else? I got 2 words. I need something unusual that will pop up.
Is that correct? And we talked about drinking yesterday. Is that correct? Okay, let me ask you a couple questions about drinking. Have you ever drank and did something that you would not normally do when you're not drinking? Okay.
Do I have to share?
Have you ever drank and said something that you didn't mean or regretted the next day that you said it? Do you
Yeah.
agree? Has that happened?
But I
If
didn't
you even
unalive
remember
somebody.
saying it. Correct? Has it ever been a time where someone had to remind you the next day or a couple of days later, you said something rude to me when you were drinking? Has that ever happened? Said things that you wouldn't normally say. Okay. They could be nice things. Yeah. Right. All right. So is there anyone who disagrees with those things? Do we all agree? Here's the thing. Do we all agree that people can do things after they've been drinking that they wouldn't normally do if they were sober? Does everyone agree? Approach.
I'm not buying them. It ain't free. Never mind. I tried. No freebie. I'm a good person. Haley Bells. I'll make one in Discord later. Oh, maybe I can make them and arrange them and then send them out to you guys for Halloween and see who wins. I'm a good mother. Outstanding mother. Y'all. I need a makeup artist and hairstylist, clothes, shoes that fit.
Objections overruled. You may continue, sir.
Thank you. Is there anyone who disagrees that people act differently when they drink? Okay. Now, Juror number 26. Yes, sir. Do you drink? Okay. Do you drink at home?
Scooby,
drink
Scooby Doo,
out
where are
socially?
you?
Okay. Are your drinking habits any different at home than they are out socially? Okay. You probably drink more socially, meaning more
Has some
occasions? or
prison
what?
guards, couture
Quantity?
guard.
Okay, good. Is there anyone here who drinks more at home than they do out socially? Okay, thank you. Juror number 38. You drink more at home than you do out socially?
I'm
Why?
kind of perplexed.
Because I can stumble to my bedroom more than I can stumble to the car.
Ooh!
Hey man, that's A+. That's exactly it.
Oh!
That's exactly it. Is there anyone here who disagrees with that?
Oh, Lord. That was good. That was good. That was good. That was good. Oh my God, that is so funny. He's right, though.
Juror number 49. Sir, first of all, I'd like to say congratulations to you, okay, and continued success, all right? And I actually appreciated the story that you shared with us. I have a couple questions, though, okay? How long have you been a non-drinker?
Since 1987.
Since 1987? Okay. And prior to being a non-drinker, how long did you drink? How many years did you drink?
Probably 15, 18 years.
15, 18 years. If you don't mind this sharing this with you, when did it come to you that you thought or recognized that you had a problem with drinking?
Well, I was going through some difficulties with a wife that I had at that time. I was overseas. The last thing I remember doing was drinking 2 beers, and I evidently blacked out, and I embarrassed myself in the Air Force.
Okay.
At least he's honest.
Sir, was there ever a time in your life that someone confronted you about drinking and you denied that you had a problem?
Actually, multiple ways, multiple directions. I had people telling me that I didn't have a problem, and I had people telling me that I had a problem.
Okay. Was it your drinking buddies who were telling you that you didn't have a problem?
Not only my drinking buddies.
Not
I
only
had
you.
commanders telling me that I didn't have a problem.
Okay.
That's a good one.
Were there loved
That
ones
was a good
telling you
question.
that you did have a problem?
Yes.
No, actually, when I confronted them, telling them they had to stop doing that, they actually got a little upset.
Okay. Who was it who was telling you that you had a problem?
Medical personnel,
Okay. Did you listen to them?
initially, no.
Okay. Sir, can you tell us what changed your mind or your attitude?
To be honest, after
I can't even
numerous
get that far.
incidents, I know my family history. I felt it either I needed to stop drinking or just take myself out into a field and eliminate the problem before I actually hurt somebody else.
Okay.
Wow.
So you looked in the mirror?
Absolutely.
Is there anyone here
That's a good man.
who disagrees with the fact that there are people who are in denial about a drinking problem? Anyone who disagrees with that?
Say it again.
All right, let me ask it in it this way. Would you all agree that some people are
I know,
in
right?
denial that they have a drinking problem?
I know, right?
Thank you.
She said she can't get drunk. I can't get drunk.
All right.
I don't get drunk.
This is what I need to ask you. now
That
as
needs to be on a
parents,
bingo card.
and I want you to understand. Because we've talked about how people act differently when they drink, or they'll say things differently, or they'll do things differently when they drink. Do we all understand that being drunk is not an excuse for your actions?
Mm-hmm.
Do we all understand that? Okay, raise your paddle if you agree with that. That being drunk is
I need
not
a
an
paddle.
excuse for your actions.
I have a gavel.
Do we understand that? Okay. Do we understand that in the state of Florida, there is no defense for voluntary intoxication? Do we understand that? So
Involuntary
you can't come in the state
intoxication?
of Florida and say,
How does that happen?
well, I did it because I was drunk. Do we understand that? Okay. Is it anyone here that would not hold someone accountable for their actions merely because they were intoxicated or drunk? Anyone here? Anybody going to do that? Okay. All right. Thank you. You ever heard, has everyone here heard the term, by show of paddles, rush to judgment?
Dang, I thought.
Rush to judgment. Okay?
Are you telling me, ADHD, that Sarah being drunk is not an excuse for my actions? Oh, darn. Dang it. I thought I had an excuse. Oh, well, darn. Kill
Is
that
there anyone
plan.
here who has a story that they can share about
Why?
them rushing to a judgment and it turned out that they were wrong?
I'm not going to go down that road
Anybody?
with you.
All right, I have one. Tell me if you can agree with this. In a building one day, come out from the building, I'd done my shopping and stuff. I go out to the
You mean
parking
from
lot,
jail?
and I'm walking up to my car. And as I get closer to the car, I see that there is a dent,
I am so sorry.
big dent,
Toy.
in the back driver's side of my car on the bumper. So guess what? I'm mad now because it wasn't there when I left. So I'm going up to it. And
I'm
I
going to start
see,
charging
man,
you
it's
for
only in my
these
car.
laughs,
So I'm
Zach.
looking
That's
for a
funny.
note, and I don't see a note to see if the person left a note or information. So then I get to the point where now, let me put this in here. Let me go and see if they have any video footage inside so I can see who hit my car. Okay? So on the thing of putting it in there, I click my key fob and the door wouldn't unlock. Now I'm really mad because they done damaged everything. Can't even get in my car. I go to the handle and I push with my thumb the button to get in, and I can't get in. I said, oh man, this is just bad. So I walk back to the back of the car and I happen to look, and I said, that's not my Florida State University license plate. Matter of fact, that's not my car. At the time, I was driving a black Nissan Maxima. At this time, this car was a black Nissan Altima without a Florida State license plate. Would you agree with me, folks, that sometimes everything that needs to be investigated? Is there anyone who disagrees with that? Okay. Would you all agree that there should be a full investigation before a decision is made? Would you all agree with that? Anybody, by show of paddles, who would disagree with that? By show of paddles, who agrees with that? Okay. You know, when I found my card too, which was behind me over there, I was relieved. But then, you know, I thought maybe that car was like that beforehand. All right. Now I have to talk about one of my, well, there's one other thing I have to talk about. Remember yesterday there was conversations about you being the, as the jury, you sit in the position of determining what the actual facts of the case are, okay? What the actual evidence of the case are, and you have the great power of giving evidence its weight. Some you can consider greatly, some you could give less weight to, or some you have the power just to ignore it all, and you don't even think it's important. Do we understand that? That's your
Well,
power
we would
as
have
jurors.
fun
So it's
in
talking
Discord.
about, one of the things we're talking about, one of the things too, you're going to have to determine credibility of witnesses. Okay? Credibility of witnesses. And they talked about some things, and the state talked about some things. Would you like to look at them? Would you just be able to hear them? Or could you be comfortable with that? All right? The judge will read an instruction when it comes time, and I want to know if everybody can follow this instruction. It's going to be weighing the evidence, and the judge is going to give you a series of things that you can use in determining which evidence is the best evidence, which evidence isn't so good, or which evidence you don't find credible at all. Do we understand that? Okay? But I want to focus on one of those. I'm telling you it's more, but this is the one I'm focusing on. Weighing the evidence. Does the witness testimony agree with the other testimony and the other evidence in the case? Do we understand that? Okay. Does the witness testimony agree with the other evidence, the other testimony, or other evidence in the case? Can we do that? Is it anyone who feels that they're not capable of doing that? Right? Now, when we say other evidence, we're just not talking about other testimonial evidence, because evidence comes in different forms. Okay? There could be physical evidence. Do we understand that? There could be scientific evidence. Do we understand that? Or there could be expert opinion. Do we understand that? Can you weigh all those things, follow the law, and make a fair and impartial decision based on the law? Correct? And based on what else? That high standard of proof, the highest that we have in our country, beyond and to the exclusion of a reasonable doubt as to each and every element. Can you do that? Guess what?
Are you
Two
done?
more things, I think. I'm going to check with co-counsel too. But two more things, basically. One is,
I'm getting
this.
sleepy, or she's getting sleepy.
I'm going
Both?
to date myself here. All right,
I'm actually doing quite good for the lack of sleep I had last night.
Okay.
I'll probably crash
and
about
in
6.
fact, when y'all had the
But I can't.
opportunity to meet Lauren Henderson, okay, she's not my wife. She's my youngest daughter. We are related. Okay, so, and actually, she's an attorney now. She just finished law school and passed the bar. So that's why she's
Congratulations.
assisting in this case today. Okay, so that's the relationship. But when it comes to weighing the evidence,
Boy, she's getting an education.
No, I'm sorry. I'm past weighing the evidence. I was getting emotional. Anyway,
Oh, gee, gas.
this is one of the things, and she has to help me with it. That's where the age difference comes in. It's called social media. Okay? Guess what, folks? I do not have a Facebook page. Quite frankly, until it started becoming prevalent and people looking at them and stuff, I added it onto my voir dire thing because they had to tell me, my staff had to tell me what the forms of social media are because I don't know them. Facebook, I guess YouTube's one too. I thought that was TV. But Twitter, Snapchat, TikTok, Instagram. Okay? So I become familiar with these things, but I'm looking for something. I'm looking for someone who lives their life on any type of social media. All right? And this is what I'm talking about. So if you're this kind of person, I want
I
you
live
to raise your paddle.
on social media. I work social media.
No, who lives your life on social media. Okay? Who lives your life on social media. Well, you'll see with this example. Okay? That's it. Some of y'all are getting nervous. I can tell. You're getting nervous, but here we go. Here we go. 6 a.m. Just woke up. 6:10, headed to the bathroom.
Cell phone in hand.
6:20. Man, I really don't want to go to work today. 6:35. Darn it. Let me go in here and see what I can have for breakfast.
Are you kidding? Most people
6:45.
have already been on social
And it
media by
looks
now.
like either Fruit Loops or eggs. 7:05.
Yeah, right.
Darn it, I still don't want to go to work, but those eggs I had were really good. Okay? 7:30. I better head to work so I don't get caught in this traffic. All right. Anyone who leads their life on any form of social media or texts anyone to that extent, would you please raise your paddle?
What?
Okay.
That didn't make sense.
Remember that word, voir dire? To speak the truth. Now watch this. Is there anyone who knows someone that does that?
That person's not
I
living
always
on
get a
social
yes
media.
to that part. I always get a yes to that part. So no one who knows that way. Is that correct? No one who doesn't. Okay. Judge, may I approach a minute, please? May we approach a minute?
Yes.
Okay. If he would have said you wake up in the morning and the first thing is you do is you grab your phone and you start checking your social media. You go to the bathroom with phone in hand, sit on the toilet and still on social media. Then you get your shower and get out of the shower and you're back on your social media. And that's how you live your life. But the example you gave is someone who's not on social media. I'm confused. I'm living in the river of confusion. Yeah, I would be surprised if this wasn't her question or encouraged question.
Continue, sir.
Thank you, Your Honor.
I'm kind of past it. Oh,
All right, the procedure.
but still.
When you get here, if you're on a jury, when you get here, you're going to have to turn your phone off.
I
You're gonna
can't
have to
legally do
leave
that.
Your phone off. Okay?
Can't legally
I think
do
they've
that.
been having y'all do that now. Is that correct? All right. Doing deliberations, you got to check the phone at the door. Okay?
Legally
Not gonna
can't do
happen.
that.
Everyone understand that? Who's going to go through withdrawals? I need to know.
I won't go through withdrawals. My problem is my phone controls my hearing aids. I adjust the volume. I modify the programs for the situations I'm in. I use my phone as a medical device more than I do for social media. So I guess I couldn't serve on a jury.
Who is going to go through withdrawals? That means you're not going to be able to text someone. You're not going to be able to get on the phone and see who's trying to call you. You know what? You're not going to be able to put that last post on there. Do we understand that? I mean, back in the day, guess what? We used to have to ask this question about cigarette smoking. Okay? I think
Yeah.
they allow breaks for cigarettes. I
Yeah.
don't think they allow phone breaks. Okay? So is there anyone who is that tied to their phone that they're going to be worried about that phone and not worrying about the evidence and the case and the testimony and everything else? Yes, sir. I'll defer to the judge.
I can answer that question. So if you are selected to serve as a member of our jury, an emergency phone number will be provided that you can provide to any loved ones or friends or family. And in the event there is an emergency situation, they can call that number and we will get in touch with you. Thank you.
What? I got to hear that.
Or friends or family. And in the event there is an emergency situation, they can call that number and we will get in touch with you. Thank you.
Okay, they did want that witness, I don't believe.
Judge, can I confer with counsel?
Yes, sir.
Real quick.
Y'all, come on, whisper just a hair louder so I can hear you. Just a hair louder. Just a little. Get a little louder. Get a little louder now. No, they won't. I'll be right back, y'all.
You are now, counselor.
I'm back on? Okay, I'm back on. There we go. You know, in our little courthouse in Santa Rosa County, you don't have to wear a mic. You know, you just, everybody said, oh, we got a new courthouse, but it's nothing like this.
Bless you.
Okay. Bless you, sir. All right. Great escape clause. I don't really think anyone has said today that they couldn't be fair or it's anything, but I know you've been responding to questions. This is what I want you to do. I want you to think about it. And if for some reason, it could be anything, okay, that you don't feel comfortable about sitting on this case, if you'd raise your paddle and let me know. But let me give you some examples because I don't really, before you do that, it could be the fact that you don't like the fact that I move around. You don't like the fact that I look. You don't like the fact of how I sound, okay? You don't like the fact of, darn, Mr. Henderson, what were you thinking about when you got in the mirror this morning? Okay, that don't match. It could be that. Folks, it could be as simple as this, that you think my hair is way too long. Okay? But now, or it could be something that you don't like about Mr. Owens, that you don't like about Miss Boone, that you don't like about Mrs. Henderson, and that you don't like about Mr. Beck. Miss Andrews is a little sensitive, so I won't say it, but you can consider that too. Okay? So at this time, if you feel uncomfortable, would you please raise your paddle at this time? Okay. Number 40. All right. Thank you, ma'am. Anybody else? All right. Folks, I want to thank you. I want to thank you on Miss Boone's behalf. I want to thank you on our team's behalf. People here have made us very comfortable. Sometimes it's hard going to a different place, but everybody's been very friendly. Y'all have been very attentive to me, and I really appreciate it. And I want to thank you on behalf of me, our team, and especially Sarah Boone. Thank you. Judge, that's all the inquiry I have.
Can the parties approach for a moment?
Uh-oh, what's going on? I see some all caps from Zach. That ain't good. Zach. Dude. I like it that y'all banter back and forth. I think it's great. So they finally indicted Colin Gary Left and his son Colt for the mass shooting at Appalachia High School that I covered. The grand jury did indict both the father and son in the murder charges on Thursday in the last month mass shooting of Apache High School in Winder. Georgia media outlets report that the Barrow County grand jury meeting Winder indicted indicted the 14-year-old and the 55-year-old. 4 counts of felony murder, 4 counts of malice murder, plus aggravated assault, cruelty to children. His father, Gary, faced 29 counts, including second-degree murder, involuntary manslaughter, and reckless
Members of our jury,
conduct.
thank you so much again for your time.
We'll be
your
following that.
sacrifice, Your attention, most importantly, your honesty in answering the court's questions, the state's questions, and the defense questions over the last couple of days. We're going to excuse you for a few moments while we decide who may be able to serve as members of our jury in this case. Please do not leave this floor. There may be some of you that we need to speak to on an individual basis. And again, I'm going to give you a similar instruction that I've given you as well over the last couple of days. Please don't conduct any independent investigation or research regarding the charge, persons, places, or things that are involved.
Were
Do not
they
have any
okay, Wendy?
communications with anyone else or amongst yourselves about any of those things.
I did
One
follow
last thing.
that. I was one of the
You may
first people
see
to
the state attorneys for
broadcast.
state and the attorney for defense outside, maybe in the same elevator as you over the next couple of weeks. They're not allowed to talk to you, and they may look away from you. They're not allowed to communicate or have any interaction with you whatsoever. If you make eye contact, they may shy away and look away from you. I promise you, they're not doing it to be rude or insensitive. They're just trying to avoid the sense of any impropriety while we conduct this trial. With that, I thank you again for your time and your sacrifice, and we'll bring you back in as promptly as possible. Thank you.
Wow, we wait and look at that wonderful footage of whoever the hell that is. I'm going to give another shout out to As the Gavel Drops on Discord. They are your place to go for any and all trial related documents and
We'll be off the
videos.
record for a few moments.
Thank you
y'all
for
to,
your support of
review
this
your notes,
channel.
use the facilities. Take 15-minute recess. It is 3:30. We'll see you all at 3:45, and we can address any individual voir dire or charging conference at that time. Court's going to be in recess. Thank you.
Oh, that pineapple was good. So is that his daughter, I guess? I don't know. Find the eagle. Come on, find the clock or the eagle. Oh, I get motion sickness pretty easily, so that just kind of was a little much. Get the focus. Oh, thank you very much. Good cameraman. Oh my gosh, y'all. We're getting there. Tomorrow will be opening. Yay. Thank you, Jesus. We're there. I know. Mm. Well, yeah, and it would be good experience for her, definitely. But girl, if she can handle this woman, she could handle any client. What the heck are you talking about now, y'all? Think the fine print says you can see the fractions every other weekend, 2/3? What? Y'all have done and gone and lost me. Y'all gone and lost me. I'm just, y'all have fun. You done lost me. I'm gone. I'm gone. I'm gone. I'm gone. I need Let's see what she says. Dang, Mr. J objects again. That's 7 objections so far, 3 overruled, 4 sustained. JMO, but I think it's a bad look. Yesterday, no objections from the defense. Interesting. What do y'all think about that? What do you guys think about that? I think I'm ready for trial. I'm ready. I wish I could use that song. Dun, 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 dun. You know, like they use at football, baseball, basketball games. So, Zach, favorite fish to catch nighttime fishing? Favorite fish? What's next in the Menendez case? Okay, no news. I was looking to see if there's any new news for that. There is not. I'm searching for news, guys. I'm looking. Hold on. Do you know what? They have been talking a lot about Maggie Smith lately. I absolutely adored that actress. Fabulous woman. And gosh, man, she was funny. Just in daily life, she was phenomenal. And I can't believe all the movies she was in. Okay, Toy Liquor. Here's the deal. We can get you 100% over 5/17 visiting rights plus full moons if you just sign the little contract, and we will go through in the same timeshare embark. Oh, guys, y'all are horrible. Y'all are horrible. How about them Cowboys? How about them Cowboys? Let's change that subject. Full and half moons. Okay. I guess I'll grant that. I'll be the judge. Granted. So should we take bets to see if she'll be in the same suit tomorrow? Is she going to wear that suit every day? That ought to be interesting. Favorite nighttime fishing, maybe be speckled trout. How do you cook it? I'm betting you keep your catch and you eat it. So how do you cook it? I'm getting hungry. Trying to think. I had toast and eggs this morning. I had a couple cookies. That's all I've had today. Pineapple. I'm getting hungry. Uh-oh, this hit just 5 hours ago. Boston prosecutors have called on the state's highest court to allow them to retry Karen Reed for the murder death of Boston police officer boyfriend, argued against the defense's claim that the jurors had reached a verdict against some of her charges before the judge declared the mistrial. Reed, we know what she's accused of. In a brief filed late Wednesday to the Massachusetts Supreme Judicial Court, prosecutors wrote that there is no bias or basis for dismissing the charges of second-degree murder and leaving the scene of an accident. There was no viable alternative to a mistrial. Quote, they argued in their brief, noting that the jury said 3 times that it was a deadlock before the mistrial was declared. Prosecutors said the defendant was afforded the meaningful opportunity to be heard on any purported alternatives. That wasn't true. She dismissed, done, out the door. I mean, everybody said, boy, that was kind of unusual. The defendant was not acquitted of any charges because the jury did not return and announce and affirm an open and public verdict of acquittal. Well, they weren't giving a chance. That requirement is not mere formalism, minstrel act, but empty technicality. It is a fundamental safeguard to ensure no juror's position is mistaken, misrepresented, or coerced by other jurors. Oh my gosh, y'all. I watched that a couple of weeks ago. I went back and watched that, and I was like, no, there was really no opportunity given nor asked if anybody had questions or anything for the jury. The defense brief filed September, Reed's lawyer said 5 of the 12 jurors came forward after her mistrial saying that they were deadlocked only on the manslaughter count, that they agreed unanimously without telling the judge that she wasn't guilty on the other counts. They argued that it would be unconstitutional double jeopardy to try her again on the counts of murder and leaving the scene of the crime or scene of an accident without the accident with resulting in death. Or arguments will be heard from both sides November 6th. Okay. So we have that November 6th. I'm keeping an eye on Miss Jules and Surviving the Survivor. That's interesting, y'all. Interesting. What? What are y'all talking about? Okay, guys. Favorite night fishing. Okay, 20. Give you half moons. Just no punching below orange. Oh my gosh, y'all. Special concept, best fresh fried. Frozen, it gets a little soggy. Yeah, I can imagine. Ooh, Zach, that sounds good. Oh my gosh, Toy. Haley Mouse, I like mine with a kiss. Zach, you have set up a precedent with kissing fish. I know, right? Y'all got to see these. Oh my gosh, y'all are being so bad. I bring my teeth before I go to sleep. Zach also note. Oh. Oh, y'all. Y'all are having too much fun. You really are. First of all, I want to thank, she's not here now, but Miss Pretend Judge, thank you so much for becoming a member and hopping on this morning. You are fabulous. Zach, once again, thank you so much. Addressing the slanderous lies and hearsay that little Miss Toy posted yesterday, I shall say for the record, once again and for all, I do not like Kenny G. Y'all, my very first concert was Kenny G. Then it was YouTube. Now, as far as the hot baths and candles, I have no comment. And then, of course, Toy comes back to clarify Zach is a deeply closeted Kenny G fan. Yeah, sorry, Toy. He's doing that. I didn't have a choice. I was taken to the Kenny G. Back then, I thought it was cool. Then I went to U2 concert. I haven't gone to a lot of concerts in my life. Not like that. Oh gosh, here comes the yawns. LOL, I missed that one. Y'all are having fun. I'm happy for you. Trying to see if they're posting. It's going to be an early night for me. I got to tell you. It was 3 hours sleep is not cutting it. In Wisconsin, the Elijah Bay's case, the boyfriend charged for unliving him. Let's see if YouTube deletes this one. Nope, they didn't. Don, they didn't. You did good. Yeah, don't we love them, Ronnie? Yeah, well, we're pretty much done with that. They got a few things they're going to do, but I think we're going to have our jury and we'll have opening arguments in the morning. I couldn't imagine them doing anything opening today. Ooh. Yeah, that lack of sleep is catching up, y'all. Catching up. I thought y'all were going to be fighting in Discord. I was going to come over to my Discord and see, but then again, you didn't say which Discord. I don't do Halloween anymore. Don't have any kids. No, when I have grandkids, I might. Right now, nope. Mm. Mm. Is that my friend? No, it can't be her. They wouldn't do that with her. Oh, is that who I think it is? No. Oh. I'm seeing an old friend of mine. I miss my old buds from my sign language school. I love Halloween, with kids or not. I love decorating outside and having a daycare. Yep, that's true. Daycare, that's cool. It's supposed to be. So we have this, we have the Ferris and the Richardson hearing, all at 8, 9 in the morning. You'll have to remind me in the morning, Ronnie. Please. Seeing if I can find any pre-cues. I don't see anything geared up for tomorrow, so we'll have to check in the morning. No, nothing's pre-posted. So is what it is. We'll see. We shall see. But if it is, I'll cover it. Aww. Well, when you have a monkey, sometimes it's not good to have all that decoration around. Mm-hmm. Yeah. Especially sometimes when she escapes her cage. Yeah, she does.
As addressed at the bench, we will begin.
Sorry, here we go.
Will be opportunity to accept or reject those persons seated in odd seats. Then it will proceed to the defense for all even seats to accept or reject. Both parties have 10 preemptory challenges for the purposes of selecting our panel of 6.
We will one day.
Once we have that panel of 6,
Maybe on a
backstrikes will be
Sunday.
permitted. If there are no backstrikes, we will then proceed with selecting as many alternates as possible. When the parties are ready to proceed with selection, please let me know.
Oh, maybe I should write down this. Okay. I'm sorry, Haley Mouse. She's in a good mood today. She's smiling a lot. Oh, we're up to par. Okay, let's go. I'm ready. You're keeping Miss Ada waiting. Oh, maybe not, because the prosecution can get rid of people that she wants. Basically, the defense, they each have 10 rejections each. Prosecution will get, I think, odd numbers. Defense gets the even numbers first. And then we go from there. We have to have a total of 6 jurors and then as many alternates as possible. He wants 8. Yep, that's a good one, Zach. There you go. Oh, good. There you go, Zach. You hit that nail on the head. They do have a jury selection professional, jury selection specialist. Oh my God, Zach, you're so good. That's her new nickname, the Fisher Price attorney. No, I don't think she'll keep it for long. Nope, I don't. Come on, guys, I'm ready to go. I got my pen out. When my pen comes out, I'm serious. I got to do a comfort break. Too much coffee. Be right back. I'll leave the volume up. Really? Okay, Zach. That's stuff that people do at night. I can't lip read sideways, y'all. You lip read sideways. You can't. I saw George. I'm going to mute. She said, that's what I thought. We have a guest, you guys.
Just a minute.
Miss Diane.
Yep.
I'm having some chips.
Oh, yeah. I wish I had some chips. Okay.
I unexpectedly found them.
So you're making advantage of that, huh?
Dawn, I'm jealous. We don't get the change of season here.
Well, it is fall here.
No, it's either summer or winter here. You get a week or two of spring and a week of fall, but we don't get the fall colors.
Oh, well, we have.
It's either alive or dead.
Then I would say we will enjoy the colors in Dallas, but I guess not. Oh, well.
Are you kidding? It's nothing but concrete where we're going to be.
I can't hear anything. They not doing nothing?
They're having a conflab.
Oh.
Mics are off.
Oh.
You're getting some loving, Miss Diane.
I am, but that's good.
You got an admirer.
That's good.
What we are is they just finished going through the voir dires of all of the potential jurors. They're going to pick and pull some that they may need to do some more on, and then they're going to pull.
Okay.
Bye, Haley Mouse.
She looks a little worried.
All right, we're back on the record. Case number 2020, CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state. Defense.
James Owens for Miss Boone.
Coming back on behalf of Sarah. All right, thank you very much. The state advised juror members that they would like to follow up with 40, 49, and 51. Defense, do you have any juror members that you would like to follow up with other than 13? Okay, all right. Let's go ahead and bring in juror in seat 40 wearing badge 201, and we'll stand when that juror enters.
Okay, tomorrow's opening arguments. Are you free tomorrow, Diane?
Not until after I'll be home about 4. I'm in school. Or my time, 3 years. Because there's an hour
Nothing to
difference,
see,
right?
Thank you. Ma'am, thank you so much, juror number 40, for coming back in.
So I'll be
We've got a couple
interpreting
of
all day.
Follow-up questions to ask of you. State, you may proceed.
I don't, okay, Jason.
State, you may proceed. Thank you.
Ma'am, I believe
I will be
before
watching.
Mr. Henderson's questioning, there was a question about potentially feeling uncomfortable or something to that effect.
Yeah, so it was mostly because of the time. I have to be at pickup of my kids by 6. And if, like yesterday, I made it at 5:59. So if at any point we go over 5, then I would not be able to make it on time.
No follow-up. Thank you.
Any follow-up? Thank you, ma'am.
Thanks.
State any position with regard to juror in seat 40 at this time. Juror in seat 40 wearing badge 201 will be stricken for cause by way of stipulation. Let's bring in juror in seat 49 wearing badge 192.
You're not supposed to be eating that off the floor. You little sneaky snot. Oh, Don, it must be beautiful.
Thank you.
I
everybody.
remember
See you.
we were in
Juror
Washington
number
State
49,
in the
good afternoon,
fall.
sir. We just had some follow-up questions to ask of you,
Beautiful.
okay? State, you may proceed.
Sir, I believe at some point during questioning, there was a point in time where you indicated you'd like to speak without the other jurors present, correct?
I did, but to be honest, I can't.
Mikey Lane.
Yeah, everything's on.
My apologies. I did say that, and I don't recall in what respect that was to, other than my comment late yesterday afternoon.
Did it have anything to do with a friend being murdered potentially?
My brother.
Your brother, okay. And did more details you wanted to share in private, or?
I just wanted to make sure that I wasn't omitting anything as we were discussing everything, or as you were asking the questions. It happened so long ago that I didn't really bring it up at the correct time. I just wanted to make sure that everybody knew.
Okay. Well, I understand that's a deeply painful experience that you went through and the rest of your family went through. That experience that you and your family and his loved ones and friends all went through with his loss, is that going to affect your ability to be fair and impartial in a murder trial? As opposed to, there's lots of other trials you could have done. You're going to be excused today if you don't make this one. They're not going to make you do another trial, but are you?
I'm not concerned with my ability for jury status. I do not believe that it will influence me because it was 30 odd years ago.
Thank you.
Any follow-up? Okay. Thank you, sir. I appreciate you. State any position as to the juror in seat 49.
No motion.
Defense?
No.
Okay, thank you. Let's remain standing. We'll bring in the juror in seat 51 wearing badge 325, excuse me.
You're correct, Ronnie. You were taking notes. What dates are our conference again?
Y'all can be seated. Thank you. All right, juror number 51, good afternoon. We wanted to bring you in because we had some specific questions to ask of you. State, you may proceed.
Okay. Good afternoon, ma'am. Was there a certain point in time during questioning that you indicated that you wanted to speak to us without the company of the
There
other jurors?
was, and I think it had to do with, it was the personality, mental stuff. Our daughter has had a lot of physical and mental health problems, has been diagnosed with multiple medical or, mental illnesses. At one point, she was diagnosed with a borderline personality disorder, which I think they decided that wasn't it. So she's just had multiple diagnoses. I think that's the question that you had wanted clarified, and I think there may have been something else. If so, I can't remember.
That was my one note. And so my question is, potentially in this trial, there might be testimony about disorders that are recognized by the DSM-5
Uh-huh.
which is what, your daughter would be diagnosed from.
Mhm.
If there's testimony about that, either by civilians or by expert witnesses, is that going to present a problem for you to sit and fairly and impartially decide that testimony and evidence that you hear and see how it applies to this case and to this defendant and this decedent?
I don't think my experience with my daughter would influence me. I think mental disorders can be complicated, though. So,
All right, and so just to phrase it a different way without going into the airplane ticket scenario that we use that in every talk. Do you have any doubt in your ability to be fair and impartial if you hear that sort of testimony and evidence?
no, I do not.
Thank you.
Okay.
Can everyone take a break
Thank you, ma'am.
and go
Appreciate
and
you.
click like on the video?
You just leave the
Please
microphone right there
like
in the seat
the
next to you.
video.
Thank you.
Show some love. I forget to ask. Leave your
State any motion with
DNA.
regard to juror in seat 51.
No, Your Honor.
Defense.
No, Your Honor.
All right, let's remain standing and we'll bring in the juror in seat 13 wearing badge 2130.
This is true, Zach. I want to go to Los Maples, but they're pretty booked. So I'm going to see if I can find a day and just go. Never been. It's one of the only places in Central Texas to really get a fall. Hi, Gabby. Oh, thank you so much. Thanks, Gabby. Gotcha. And the volume is out. Why?
Case, the state husband
Why?
for a domestic battery charge.
Hold on.
All right. Are you the alleged victim?
I don't know why that happened. That's interesting. Sorry.
Thank you. Juror number 13, good afternoon, ma'am. We just had some additional follow-up questions to ask of you. Mr. Henderson, you may proceed, sir.
Good afternoon, ma'am.
Hi.
Yeah, podium's right here, Mr. Henderson, front center.
Good afternoon, ma'am.
Hello.
I believe it was yesterday when it came up, but you said that you're going to be testifying in a case.
Yes,
Is
sir.
that correct?
Yes,
Could
sir.
you tell me what case that is?
It's a case, the state against my ex-husband for a domestic battery charge.
All right.
Oh,
Are
yeah,
you
she's
the
gone.
alleged victim in that case?
Yes, sir.
All right.
Sayonara.
Due to the nature of this case and what you've heard in the questioning, do you think you can be fair and impartial?
I think so, yes.
Excuse me?
Yes.
Okay. Do you feel, what's your relationship with the state attorney's office now?
I don't have one.
Okay. Do you feel because they are representing you well, not really you, they're representing the state, but you're the victim in the case. Does that give you any feeling that you have allegiance with them or anything like that?
No, I would hope that this would have no impact. I would assume so.
All right, thank you, ma'am. I don't have
Hope.
any further questions.
But that can
Any
change.
follow-up? Thank you, ma'am.
I don't think they're going to pick
Stating any
her.
motions with regard to juror in seat 13. Defense. Okay, all right. You all can be seated. Thank you.
This is real life.
Are there any additional
Yeah.
cause
No Scooby-Dooby-Doo
challenges on
snacks.
behalf of the state? Yes, sir.
How would you sign Scooby-Dooby-Doo?
May I remain seated?
Yes, sir.
I don't know what's going on with my computer. There we go.
Juror in seat 34 wearing badge 310 will be stricken for cause by way of stipulation.
$44.
Stipulate.
Juror in seat 44 wearing badge 506 will be stricken for cause by way of stipulation.
Seat 48.
Stipulate.
Juror in seat 48 wearing badge 4045 will be stricken for cause by way of stipulation.
No additionals.
Any additional cause challenges on behalf of the defense?
No, Your Honor.
Okay, all right. I believe that leaves us with 38 potential jurors remaining, if my math is correct. We will begin with selection at this point in time, starting with seat number 1. State, acceptable?
Judge, excuse me. Can we make some seating arrangements because I have to receive because I'm gonna
Sure.
have to-
If you need to move, go ahead, sir.
Yeah, she doesn't get her snackies in court. She cannot eat snacks in court. That was not a surprise for me. This attorney is all like, dude, I'm being left out of the picture here. I need to sit with my team. It's like, how rude of you. Guys, yoo-hoo, I'm here, Your Honor. I want to let my team know I'm here. They're forgetting about me. I know I'm
All right,
being facetious,
starting
but
with
it's
seat
true.
number 1, state, acceptable?
Acceptable.
Defense? Seat number 2 was previously struck for cause by way of stipulation. 3, state.
Acceptable.
Defense? 4, defense? State?
First peremptory.
Any response, defense?
I can't
Any
hear they.
response to the peremptory challenge is to juror in seat 4. So stricken. Seat 5.
Acceptable.
Defense? 6, defense?
Zach, you're a mod. I don't tell my mods what to do.
Acceptable. 7, state?
Acceptable.
Defense? Any response, state?
No, sir.
That will be juror number 7 wearing badge 380 will be struck by virtue of the defense's first preemptory. 8, defense? State?
Second peremptory.
Any response? None. Juror in seat 8 wearing badge 361 will be struck by virtue of the state's second preemptory. 9, state?
Acceptable. I'm sorry, acceptable.
That's fine, appreciate you. Defense? 10 and 11 were previously struck by way of stipulation for cause. 12, defense. Any response?
No, sir.
Juror in seat 12, wearing badge 837, has been struck by virtue of the defense's second preemptory. 13, state.
Acceptable.
Defense. I believe that we have a panel. A panel currently is jurors in seats 1, 3, 5, 6, 9, and 13. Any backstrikes, state.
Seat 6.
Any response? Juror in seat 6 will be struck by virtue of the state's third preemptory. Any additional backstrikes, state?
No, sir.
Any additional backstrikes, defense? Picking up on 14. Defense. Any response?
No, sir. So that's alternate strike 1.
We don't have a panel, sir.
Oh, I thought we.
No, we had 6. Currently of 1, 3, 5, 9, and 13.
Acceptable. Sorry, no objection to their peremptory. I guess that's.
Juror number 14, wearing badge 537, will be struck by virtue of the defense's third preemptory challenge. 15, state.
Acceptable.
Defense. Believe that we have a panel. Our panel currently is 1, 3, 5, 9, 13, and 15. Any backstrikes, state.
No, sir.
Any backstrikes, defense. You may.
Well, we may get to, well, no, it's 4 o'clock there. I don't think they would do an open comment statements day. Tomorrow will be open statement day of jury trial. It's going to be busy. I got 2 trials and a hearing all at the same time tomorrow. I have 3 lives going the other day and a 4th one geared. Oh, Gabby. I like it when y'all have fun.
You're having fun.
They are. Zach talked to her. She talked to her doctor about it, and she's resting up. So she should come back in and get that child support from you. They're bantering, and I love it. It's fun.
Any response, state.
No,
They all know each other well.
Juror in seat 1, wearing badge 134, has been struck by virtue of the defense's 4th preemptory. Any other additional backstrikes?
No, you are.
Any additional backstrikes, state?
No, sir.
All right, picking up with 16. Defense. State?
Acceptable.
I believe we have a panel. Panel is 3, 5, 9, 13, 15, and 16. Any backstrikes, state?
No, sir.
Any backstrikes, defense? I can, sir.
Really?
3, 5, 9, 13, 15, 16. Yes, sir. Of course.
Because you love it, Zach. You do. Zach, you live off of the picking. That's why you come here. And you like to dish it. So if you dish it, you can take it, dude. So they have 6. The judge would like to have 8 alternates, ideally. As many as he can get, because they've already got 1 person that came in with COVID.
Any response?
Oh, no,
state?
Zach's not innocent at all.
Juror number 3, wearing badge 899, been struck by virtue of the defense's 5th preemptory. Any other additional
Really,
back
y'all?
strikes?
Yeah, just quit going back.
Defense?
No, Your Honor.
State? Yes, sir.
Yes, I am. No, I'm not.
You've used 5. Any other additional back strikes? State?
No, Your Honor.
Picking up on 17.
Whose
State.
Discord are you talking about, Gabby?
Acceptable.
Defense?
Acceptable.
I believe we have a panel again. Jurors 5. Yes, sir.
But he is.
Any response?
No, sir.
I have
Juror
this
seat
gamed up.
17, wearing badge 57, will be struck by virtue of the defense's 6th preemptory challenge. 18, defense. State?
4th peremptory.
Any response, defense? Juror number 18, wearing badge 7, struck by virtue of the state's 4th preemptory challenge. 19, state.
Acceptable.
Defense? Any response?
No, sir.
Here.
Juror number 19, wearing badge 891, will be struck by virtue of the defense's 7th preemptory. 20
I
was
only get
previously
10.
struck for cause. 21.
Acceptable.
Believe that we have a panel. Panel is 5, 9, 13, 15, 16, 21. Any back strikes, state?
No, sir.
Any back strikes, defense? The first, of course.
Are you kidding me? They need to. Who's? Oh, Gabby, who do you mod for?
Okay. Our jury panel will be jurors seats 5, 9, 13, 15, 16, and 21. We will now proceed with selecting any alternates. Yes, sir. I can't, sir. 5, 9, 13, 15, 16, 21.
Hey, Gabby, who do you mod for? I'll go sub, help the numbers.
Thank you. Juror number 22 was previously struck for cause, 23 for an alternate position. State.
Acceptable.
Okay. Juror number 23 will be serving as our first alternate. Moving to juror in seat 24. Defense.
Oh,
Any response?
No, sir.
I was called
Juror
myself
number
alternate
24,
juror.
wearing badge 235, will be stricken by virtue of the defense's
I
8th
didn't
preemptory challenge.
to change my name.
25 was previously struck for cause. 26. Defense.
I have a question on the process. We're at the alternate.
Correct, sir.
So at this point in time, it starts over because we have alternate down. Is that correct?
Yeah, the way I marked his down was as defense alternate 2 strike.
I'll go check them out.
Because it was our second alternate, but
Gabby, can you post her link so I can go find her?
Many alternate
Because there's
strikes as
several.
seat alternates is what I believe our agreement is.
All right, that's fine by me. All right.
I don't think, I thought I only had one alternate.
Well, but it was, I just marked it as, because we're shooting for alternate number 2. So I'm just trying to keep track of that for, but
I understand what you're saying. So I've used one alternate.
yes, sir.
That's correct.
All right, I'm ready.
25 was previously struck for cause. 26. Defense.
Thank you, Ronnie.
Any response?
No, sir.
26, wearing badge 165, will be the defense's second alternate preemptory.
I wonder how many they get for the alternates.
27, state.
Acceptable.
Defense? Juror number 27 will be our second alternate. 28. Defense.
Acceptable.
State. Acceptable. Juror number 28 will be our third alternate. 29. That's the state's call. It's odd.
I'll use an alternate strike.
Any response, defense? Juror number 29 will be struck by virtue of the state's first alternate strike.
All right,
30 was
tell her I
previously
subbed.
struck for cause by way of stipulation. 31, state.
Acceptable.
Defense?
I didn't know
Any
that.
response?
No, sir.
Juror number 31 will be struck by virtue of the defense's third alternative strike. 32, defense.
Did we get 29 and 30?
I don't remember. Too long ago.
32 will serve as our fourth alternate. 33,
Okay.
state, it's odd.
Acceptable.
Defense? All right, 33 will serve as our sixth alternate.
80K.
I'm sorry, I'm one ahead. I already wrote it in for 5, I apologize.
You can tell
34 was previously struck for cause. 35. State.
Acceptable.
Defense. Juror 35 will be our sixth alternate. 36, defense.
No response.
Juror in seat 36 will be struck by virtue of the defense's fourth alternate strike. 37,
Acceptable.
defense. Acceptable. 37 will serve as our seventh alternate. 38, defense. Acceptable. State.
Acceptable.
We have an alternate panel, a total of 14. Our alternates are 23, 27, 28, 32, 33, 35, 37, and 38. Any black strikes, state.
Seat 35, alternate strike number 2 for the state.
Any response?
I mean, I'm not 30, did I say 35?
You said 35, yes, sir.
33.
Okay. All right, juror in seat 33 will be the state's second alternate strike. Any additional back strikes, state.
Not at this time.
Any additional back strikes, defense. 39 and 40 were previously struck for cause by stipulation. 41, state.
Acceptable.
Any response?
No, sir.
All right, juror number 41, wearing badge 76, has been struck by virtue of the defense's fifth alternate challenge. 42 was previously struck for cause by way of stipulation. 43, state.
Acceptable.
Defense. I believe that we have our alternates. Our alternates at this time are 23, 27, 28, 32, 35, 37, 38, and 43. Any back strikes, state.
No back strikes to the original panel or the 8 alternates.
Defense. Any back strikes? Yes, sir.
Hey, Gabby, can you get me in contact with alternate juror? See, I started out as the alternate juror because when I Googled in YouTube, nothing popped up as alternate juror. Then someone led me to this page, her page, and I changed my name. I'd love to visit with her and maybe have her on a panel.
Judge, we're satisfied as to both the original panel and alternate.
Okay, so our alternates in this case will be juror in seat 23, 27, 28, 32, 35, 37, 38, and 43.
State accepts the panel.
Defense, do you accept the panel? Yes, sir.
Here's my email. Tomorrow
Very good.
I will be
Can the parties approach for a moment?
2 full lives and a hearing all at the same time tomorrow. I joined the Discord so she could message me in her Discord. I just joined her Discord. But anyway, this is going to be interesting. I wonder what they're going to do. So I'm going to clear these pages out and write down the numbers. We need to get the stats. I'm sure Jules is going to give it to us. Hey, Ronnie, I'm going to ask of you to do some work. Can you make a add it to our Excel paperwork, the numbers of the jury and the alternates?
Ms. Boone?
And
Good
then-
afternoon, ma'am. I have a couple of things to go over with you.
And then
before
we'll
we bring in our
get the
panel.
information
You were
from
previously
Jules.
sworn this morning. You've been present throughout the entire jury selection process that began on Monday. You've been seated at counsel's table either here in 23 Alpha or 12 Alpha, the Orange County Courthouse, and you've been able to observe the jurors during that entire process. Were you able to hear the questions asked of the jurors and their responses?
Yes.
Did you confer with your counsel about who you wanted or did not want to be selected for your jury?
I did.
Do you believe you were given a meaningful opportunity to participate?
Yes.
Is there anyone that you wanted to keep that your lawyers struck?
No.
Are you satisfied with your attorney's performances so far in this trial?
Absolutely.
Do you agree with the panel that has been selected for your case?
Absolutely.
Is there anything you would like to bring to my attention at this time?
No, thank you very much.
I'm getting ready to send them to you.
When the court reads the 2.1 preliminary instruction, defense, would you like me to read the defendant's right to remain silent section of same to our panel?
Yeah, sure.
All right, thank you very much.
Okay, I just sent them to you, babe.
Bring our panel in, state.
No,
No, Your Honor.
make the
Defense.
list and
No,
then
you
we
don't.
need to fill it
Okay.
in. So there's the numbers.
Let's go ahead and bring back in our panel.
I'm gonna
We will
stream them.
stand. Madam Clerk will identify them by their badge number. I will ask them to
Oh,
remain
we want to get
seated
their badge numbers.
where they are, and then we'll excuse
I'll
the
send
balance
those
of the
to you, too.
panel. I will give them an instruction. Court will then read the 2.1 instruction and 2.1A note-taking instruction and provide explanation for where we will be tomorrow morning. So let's go ahead and stand and bring in our panel.
Okay, so what I'm saying, Ronnie, is I'm going to give you the numbers. I'm going to stream their live tonight. So we'll have it. I'll be here with their stream because I want to boost it. You're fabulous. Or I can write it. I just can't put it in there. I'll give you the information. You enter it. Hey, Gabby, thank you so much for joining us. I really appreciate the new people. By the way, for those who subscribed today, well, for the rest of the month between now and Halloween and become members, you get entries into a Starbucks tumbler Halloween edition. 1 subscribe equals 1 entry. A membership is 10 entries, maximum of 11. I have a purple back here that glows in the dark. It's got the little dots on it that glow. It's kind of cool. The straw glows. I've got a couple of them. I got an orange one, I believe, and then I got one with pumpkins and UFOs. I don't know why, but that was their Halloween collection this year. So, okay, wonderful.
I know why it glows in the dark. Why? So you can find it when the lights are off.
That's a joke Zach would have said.
Well, it's true.
That was a Zach joke. Zach, she's beating you. She's beating you. She pulled a Zach joke. A Zach zoke. A Zach zoke. What the hell? A Zach zoke. Oh my gosh, I'm losing it.
What
State, do you
happened?
recognize our panel?
Yes, sir.
Defense, do you recognize our panel?
Yes, Your Honor.
Thank you. All can be seated. Members of our panel, we have been able to select a jury to serve in this case. Madam Clerk is going to call you out by your badge number, not the paddle number that you've been using all yesterday and today. Please stay in your seats when your badge number is called. Madam Clerk?
Juror number 295. Juror number, you want to stand? So.
Please, if you could stand when your name is, your badge number is called, please. Thank you.
Juror number 9. Remain standing. Juror number 569. Juror number 515. Juror number 130. Juror number 249. 249. Juror number 448. Juror number 110. Juror number 306. Juror number 33. Juror number 519. Juror number 2130.
What?
Juror number 413. And juror number 102.
What was the third from the last? 2130? That didn't make sense. How did they get 4 digits?
State, do you recognize the jury is selected? Yes, Your Honor. Defense, do you recognize the jury is selected? Bless you.
Yes, I do, Your Honor.
All right. Thank you. You all can be seated. Thank you very much.
Diane, Zach's hollering at
To the
you.
members of our
Really
panel
good
that were
job.
not selected, I thank you so much for your time and your participation and your attention in this very important process. You have my thanks, the thanks of the lawyers, and the thanks of Ms. Boone. It is entirely up to you whether or not you would like to discuss this case. You may do so, or you may decline. That privilege is yours. Please proceed now back to the jury assembly room, where they
I'll
will
be right
validate
back.
your parking,
Hold on
provide you
before-
your jury certificates, and give you further directions. Thank you, God bless you, and have a great rest of the week. Please don't go anywhere. Mary, do call one more time. Okay, please.
I'm just gonna do a roll.
Y'all can be seated. Thank you.
Just gonna do a roll call. You don't have to stand, just raise your hand. Juror number 295. Juror number 9. Juror number 569. Juror number 515. Juror number 130. Juror number 249. Juror number 448. Juror number 110. Juror number 306. Juror number 33. Juror number 519. Juror number 2130. Juror number 413. Juror number 102.
All right, thank you. All right, members of our jury, I have a couple of instructions to read to you. Oh, yes, Madam Clerk needs to swear you in. So if you could please stand up, raise your hands, please.
Do you swear or affirm to truly try the issues between the state of Florida and the defense and render a true verdict according to the law and evidence, so help you God?
Thank you all very much. You can be seated. Ladies and gentlemen of the jury, you've been selected and sworn as the jury to try the case of the state of Florida versus Sarah Boone. This is a criminal
You poor
case.
babies.
Ms. Boone is charged with murder. The definition of the crime charged will be explained to you later. The state's charging document, which is called an information,
Sure,
is
toxic.
not evidence, and it is not to be considered by you as proof.
Those four numbers
of any
were
guilt.
130.
It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusations beyond a reasonable doubt against Ms. Boone in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may also be produced as evidence. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then have the opportunity to make closing arguments. Following the closing arguments by the attorneys, the court will conclude with the final instructions. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify court personnel of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the court deputy, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case.
Yeah,
or the
right,
people
Gabby?
involved in the case. Do
Toxic,
not
I
take
sent
photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. End of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. The contact phone number will be provided to you. The case must be tried by you only on the evidence presented during the trial, in your presence, and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result, which would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions, such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it was made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted as so to consume as little of your time as necessary for a fair and orderly trial of the case. Members of our jury have one additional instruction to read to you regarding note-taking. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You will be provided with a notepad and pen for your use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the court deputy will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the court deputy will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence.
True, true.
With that, members of the jury, we will pick up tomorrow morning in courtroom 12A of the Orange County Courthouse, and we will begin with opening statements at that time. I instruct you to follow the instructions that I've just read to you, including not reading any newspapers or watching the local news, having any conversations with anyone, or conducting any independent research or investigation as to the persons, places, things, and charge in this case. With that, again, I thank you for your service, and we will see you in 12 Alpha tomorrow morning at 9 a.m.
Wow. It's going to happen. It's going to happen. We finally are going to get to trial.
How long's it?
Hell has frozen.
Over?
May the parties approach for one moment.
No, it'll freeze over when we're done.
Did he say he'd see him at 12 a.m.?
No.
Are you sure?
12 a.m.?
Yeah, that's what he
What
said.
time did... All right, what time is trial, y'all? I bet she wears a red shirt tomorrow, and she'll be in the same suit. This is the third day she's worn that suit.
Woo, I bet it's
Ain't gonna get stinky. 9 a.m. I thought that's 8 my time.
Okay. I will be already in school.
School. He said courtroom 12 Alpha, the courtroom number 12 at 8 a.m. our time, 9 a.m. their time, right? Please don't tell me 8 a.m. their time. That's 7 my time. I have to be up at 5:30. Oh, please say, y'all, let's clarify. Do you know what? I know what I can do. What the heck? I got all the control. I can go back. I got the
Just read to
control.
you, including not reading any investigation as to the persons, places, things, and in charge with you from the courtroom. During recesses, the court deputy will take possession of your notes and will return.
Okay, Florida time. We're good. Okay, Florida time.
Woo.
I don't want 8 a.m. Florida time. I've done that already.
Yeah.
Karen retrial, man. I was here at 8. That was 7. I was here at 6:15 every morning. Y'all. I would have a coronary.
Oh,
Might as well sleep here. I still got homeworks to do.
Once we get off air, I need to talk to you.
Uh-oh.
Oh, it's good.
May.
It's good.
I've conferred with my client about the issue on cross-examination of her ex-husband, Brian Boone.
Hey, Flash Fan
about
85.
the family law case, the dissolution of marriage case. And through my cross, if I explore those issues, it may come out that she's been in jail pending her arrest back in February the 24th of 2020. So
No, you're going to try and get her out.
she understands that may open the door. It may come out. She understands that I have to make a decision about whether to explore that area of cross-examination, but I believe she's going to say that she trusts my judgment. She is concerned about it coming out that she's had 8 prior attorneys. She does not want that coming out, but that's her biggest.
We'll address that in just a moment. Ma'am, I don't want to go into the specifics of any conversation you've had with any of your attorneys on that issue. I just need to know whether or not you've had those conversations, okay? Is what your lawyer just represented accurate as the conversation that you've had as to that issue regarding cross-examining your former husband, Brian Boone?
Yes.
Okay. Do you understand the risks that if he seeks to impeach or call into question the bias and credibility of your former husband, Mr. Boone, as to what has transpired in your dissolution of marriage case, it may open the door to the fact that you have been incarcerated since February of 2020?
Yes.
Are you in agreement with that strategy, understanding those risks?
Go for it.
Okay.
I'm going to be
Now,
tired
with
tomorrow.
regard to your concern, ma'am, over having 8 prior attorneys, I don't intend on allowing it. I'm sure that's not part of the state's case in chief.
No, Your Honor, I don't see how it would possibly become relevant, but if we somehow believed it did, we would certainly have a sidebar before anything about that.
If by some circumstance that somehow becomes relevant, I'm going to ask the state to approach before we even get near addressing that issue in front of our jury. Okay? Ma'am, do you have any other questions for me at this time?
I do not.
All right. State, anything further?
No, sir.
Defense, anything further?
Yes, sir.
All right, we will see you all tomorrow morning at 9 a.m. The court will conduct its regular docket at 8:30. Thank you. We're off the record.
Oh, goody. So that means they're going to probably be late again, depending on his docket. Wow. Thank you, Kristen. Thank you. Let it go. Let it go. I hate that song. Yes, y'all go to Discord and over to talk to As the Gavel Drops. I have been blasting you all day, Toxic Orchid. I need to get my other sponsors out there too. I keep forgetting. Oh. Okay, guys. Okay. My typing is sucking.
Oh, well, it goes sometimes.
I'm just tired. I only had like 3 hours sleep last night.
And she's got chains on her.
Hmm?
That chain.
Oh, now they're going to shackle her. I hate that yellow. They're picking the sea green and yellows with that color suit. It just does not look well.
It's not her colors, but she doesn't
And
like me too.
and it's blending too much into the walls and ugh. Ugh.
Some people got it, some people don't.
Okay, so we're going to watch them walk out. I always like to see the body language and what they do and what they say and how they behave. Just made some new friends. Okay.
Okay. Just for
Yes,
me.
they're not going to do it. Let me in the live. I'm going to hold you. Everybody, thank you so much for joining. I will be going live. I think it's 7 my time. But be watching for it. Jules and Squeegee of Justice are going to be giving a recap live. I'm going to restream there so to help expand their audience. I'm not going to be live with them, but I will be hosting. I will be rebroadcasting their live. So join them, join me. It's up to you, but thank you so much to all the new people. Please make sure you subscribe before you leave. Just put I sub in the comments, even on the replay. It'll catch it, and you'll be entered into the drawing on the 31st of October. In the meantime, I need to take a break so I can come back on. We shall see you shortly. Bye.
Bye.
Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.